Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihi Anglican police service, but
Is that correct?
I didn't ask you to interrupt me. Oh, for crumb's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. A little bit late getting back from lunch here. Had to run to the UPS store, and little Stubby knows why. It's on its way, finally. It's on its way. Big shout out to Sample User. I don't know who was first in chat. This live stream is the... Thank you, Sample User. Thank you. I don't know who was first in chat, but the first in chat gets the internet. Paula Mac says it was me. It was me. It was I. I'm the problem. It's me. Paula Mac says, congratulations. Paula Mac, the internet's all yours. Congratulations. Wonderful. Paula Mac for the win. Everything I related worldwide is now your responsibility for the rest of the day. Why am I talking fast? Because I want to get to this court before it goes away. Before it goes away. And we have to watch 1.25 speed just to make it work. We're going up to Thurston, Washington, where we're way far behind.
Eddie Woolley as the plaintiff and Michael Davis as the defendant.
We've got a civil thing going on. What is up here in Thurston?
You can both turn on your cameras and your video.
I've got to go somewhere else apparently.
And
Judge.
what we
Gave my
need
spot
to
away.
change out clerks again?
No, we're
We're
good.
fine for now? Okay.
We're good. Maybe I go right.
Go ahead and proceed that matter.
Who's smoking? Who's smoking?
All right, Ms. Woolley, would you raise your right hand? You solemnly swear or affirm that the testimony you're going to give today is the truth and nothing but the truth?
Yes, ma'am.
Okay, and Mr. Davis?
Yes, Your Honor. Sorry.
So I'm going to ask that you go ahead and take a seat and get ready for this. I know that you're on Zoom, but this is a court hearing.
Yeah, sorry.
If you could raise your right hand.
Nike, not a sponsor.
You solemnly swear or affirm the testimony you're going to give today is the truth and nothing but the truth?
Yes.
You can
All right,
put your
Ms.
hand
Woolley,
down.
if you would like to go ahead. Again, what I'll be doing is I'll be hearing from you. I'll then be hearing from Mr. Davis, and then I'll give you a brief opportunity to respond.
Okay. I brought this claim today. We had an agreement. We've got a child together, which is two and a half years old now. I have been the sole provider
Congratulations.
from him since his birth.
Oh.
In which point, 5 months old, I had to move back to Tennessee in order to get help with finances and childcare and basically anything I needed as far as supporting the child. So I did what I needed to, moved back to Tennessee. At which point, there had already been a parentage case that was opened in the state of Washington that was opened in August of 2023. We appeared in court October of 2023. The judge granted the motion for paternity testing. Paternity testing was done in February the following year. Paternity was proven on our son in March of that same year, of which point the discussion between Mike and I had been for Mike to meet Jaden for the first time. In August of
You've got a child.
2024, we had communicated in which Mike had agreed he wanted to come out, meet Jaden for the first time. So I agreed to it. There was an original agreement at that time for if he wanted to fly out and meet Jaden, I would fly back out to Washington in order to pick Jaden back up. With this being said, we also had numerous conversations as far as the trip being about Jaden, him spending time with Jaden. Initially, I was under the impression it was going to be a week that he spent time with Jaden. However, that week was shortened down to a Friday through a Sunday trip to Tennessee to meet his child that I had been taking care of for the first time ever.
You've been taking
He
care
flies
of for the
in
first time, or he
on
me-
Friday, August the 11th, at which point I did submit evidence to show that basically he made the statement that he could be available to my schedule after having the conversation of having to leave work, making arrangements for him to see Jaden, spend time with Jaden, so on and so on. Therefore, I ended up, because of lack of communication, having to miss an entire day's work that Friday that he flew into town. Through the period of Friday through Sunday, there was a total of 9 hours that was spent with our child. For the first time meeting him in his life, Therefore, as a mother that had been solely providing for him for an entire year of his life, I was not comfortable sending him across the country with somebody that basically was still a stranger to him.
Ah, the plans changed. I see.
Therefore, when I started getting cold feet on the situation, Mike decided, by begging and pleading, me giving in, because as a mother, I do want a father figure to be present in Jaden's life.
Just not.
I agreed
now
with evidence that yet I've supported that if he were to fly Jaden back to Tennessee, that I would agree to it. Therefore, I did agree to it because he showed me proof of the plane tickets, that he had intent to return to Tennessee on the date we had discussed, just to get a text message while I'm at work on Wednesday the following week saying that if I wanted to come get if I wanted Jaden back, I had to come get Jaden from the state of Washington. With that being said, of a mother that has taken sole care of that child for an entire year of his life, I did what I felt any mother would do. I dropped everything to fly across the country to get my child to make sure he was safely returned to me, because I still had not had any civil conversations at which point that benefited either me or Mike as far as his involvement with Jaden. So all the expenses that trip cost me was from the equity from my previous divorce. And I retained a lawyer while in the state of Tennessee because we did not have a parenting plan in place to say who had custody of Jaden and who did not.
Okay.
I had already been misled on August the 11th when he dropped Jaden back off to me, saying that he was going back to his hotel to rest, to find out the next day when he carried conversation with my best friend that he and his girlfriend had basically went out on the town after telling me he was going back to the hotel to rest. Therefore, that was the more than second time.
I'm sorry to interrupt you. I'm sorry to interrupt you, but that's the nature of these hearings, is that I get to interrupt and to ask questions. Did I hear you right that there was not a parenting plan in place at this time?
Correct.
Okay. And then I just want to clarify. So Michael came out Friday through Sunday to visit, and then after that he flew back to Washington?
Yes, ma'am. Yes, ma'am.
And the understanding was that Michael was going to bring him back?
Yes, ma'am.
Okay, but at this time, there was no parenting plan or anything in writing about this.
This is not about the child.
Correct.
This is about the money.
There's more
this is
to it if I can continue. Am I allowed to continue?
Yes, please do go ahead. Thank you for.
When I got to the state of Washington and dealing with not only Thurston County Sheriff's Department, I dealt with Tumwater Police Department. I dealt with Pierce County in order to guarantee the safe return of my child, because I had been told basically that I was not getting my child back until the date that we had originally agreed on. I filed through Pierce County, which was later granted a habeas corpus in order to get the child back. Therefore, the law enforcement could enforce for me to get my child back. I also, at that time, filed a parenting plan with Pierce County at that time, therefore, to get the process started of the parenting plan, because I was not aware the way the parentage case read was it basically was just acknowledging both of us as the parents. It did not say who had custody and who had not. However, again, I was the one that has been supporting this child from the very first day of birth. So at which point I jumped through hoops while in the state of Washington in order to guarantee that I did get my son back in a safe manner, back safely with me, because I had already been misled by Michael. And how was I to know that I was going to get him back on the day that he said he was going to give him back? I wanted to make sure that happened, because as any mother would do, that child has been in my care since day one. And with this being,
3 days.
I'm sorry.
Did you have more?
I do. The day that they flew into town, we had conversed about me only taking a partial day of work off. And I was told his exact wording on the exhibit is, you tell me when you're available. I'm available all day. I made this trip to see Jaden. That's his exact wording on the message.
Michael's nodding. Sounds
Therefore, I was trying to be available. I ended up missing the entire day of work because of the lack of communication for that Friday. Not to mention, when I got the text message to tell me if I wanted Jaden, I could come get Jaden. That was also my last day of employment, because while I was out of town fighting to get my child back, I get a text message from the employer that I was working with at the time that said, due to my current situation, they were ending my assignment at work. So I lost my job on that too, to make sure basically that I got my child back, our child back.
Okay.
Thank you.
That paints a picture.
Mr. Davis?
Yes. So, yeah, what she's not telling you is that and she briefly went over it, was that, and she actually didn't tell you that there was a previous trip that was supposed to be planned for me to come down and see him and be there for his birthday, where plans were in place. No tickets were bought, thank God. But she decided that at that point in time she didn't like me, so she didn't want me to come. There was multiple conversations prior to us arriving in Tennessee for this trip. Multiple conversations about her picking him up from the airport, me going down to see him. There was no set times where we said, I'll have Jaden from this time to this time, and from this time to this time. There was nothing like that was said. When I did land, I told her, I said, hey, I'm here. It was like 5 o'clock in the morning. I was like, I'm here. Whenever you have time. I don't remember my exact words, but I made her sure to know that I was available. She and then returned back and said, and I don't know if she put that text message in there, but she did tell me that she didn't like the way that I was talking to her, and that I would not see my son for the entire trip at that time. So at that point in time, I knew it was going to be a fight with Kelly, because she sometimes likes to have control that she thinks. So yes, that first day I met my son for the first time. We had a great time. We did go back to the hotel, and honestly, what I do on my free time when I'm not with my son should be of no concern to her at all. Whether I tell her I'm going back to my hotel to rest or I'm going back to my hotel to do whatever, if I'm not with my son, and when I'm with my son that he's taken care of, which there's never been a complaint that he hasn't, it's really none of her business what I do with my free time. Whether I wanted to go out and see downtown Nashville because I had never been to Nashville before in my life, or if I wanted to go sit in the hotel pool. But she made it about her, and that I was I guess when I was supposed to come to Tennessee, it was just supposed to be be in my hotel waiting to be available to her or whatnot. The original plan did not get changed until Sunday, when she brought that up, saying, "Oh well, you didn't want to spend any time with the child. You went out to downtown Nashville and partied it up," which was not even close to the truth. Yeah, and the whole time that we had Jaden, she would like to state that she was tracking me, but she was not tracking me at that time, because when we got back to the hotel Sunday night, getting ready to leave.
To go ahead and so the crux of this matter has to do with
money,
whether there's any money owed to Ms. Ruley for her expenses to fly out to Washington. So maybe if you could go. I understand that you're upset by some of the things that she said, but those aren't things that necessarily come into my
there was
judgment.
never an agreement to pay for anything. There's never. I mean, we're getting to that point. So yeah, she then at the very last minute said, "Oh well, you have to buy a ticket back, this, that, and the other thing." And I had bought the ticket and fully intended to do that. Then, like I said, there was no parenting plan in place. So then, as we get back to the hotel that night, she is tracking us. She had put trackers in Jaden's car seat that we had to, dig for and find. She also put trackers in his bag. So when we get back to Washington, I tried to file cases against her for that, because it's illegal tracking. But the judges, it was a pain in the butt and never happened. So at that point in time, I told her, I said, you're gonna have to fly back out here. Changed it just like she had changed it from the original agreement. And then she ends up showing up at my house.
I understand, right, that you changed it. Did you change it because of the trackers?
Yeah. And after speaking to attorneys and stuff like that, there was no parenting plan in place. So whoever had possession, I hate to say it like that, but whoever had possession of the child had possession of the child. So then she ended up, I guess, flying out here, like I said, because she showed up. The cops came. The cops told her the same thing that they told me, is that there's no parenting plan in place, so there's nothing that they could enforce. Whoever had the child, and I had the child at the time. I had all intentions of giving Jaden back to Kelly at the time that we had stated.
Sad,
I actually returned him a day early, because she had her attorney call me, and he was begging and pleading that I'd return Jaden for a birthday party that wasn't even on the agreement. So she changed the agreement again and wanted him back a day early than what was supposed to be happening. Yeah, I never agreed to pay $9,000 to come to Washington, because you decided that you wanted to not hold up your end of the agreement, because she just said that she didn't have any money, that she was broke yet. She had money from a previous divorce that she could fly back out to Washington. So I mean, she lied to me initially when she said that she didn't have any money to deal with Jaden.
What are we drinking, sir? Is that a Dr. Pepper?
Because if she didn't have any money, how did she fly out here? She just stated that she had money in from her previous divorce or whatnot.
9,000. Did she rent the whole
her
plane?
Lying to me about not having money to fly out was just a part of her thing that she does. I mean, she's taken me to court plenty of times. So
I know the routine.
Ms. Rulli, did you? What information would you like for me to know? And again, I want you to focus on any agreements that you had, as opposed to any discord that you had with Mr. Davis. And also, if you could walk me through, I didn't understand all of the expenses that you had highlighted. If we could talk about that as well.
Okay.
Agreements versus disagreements.
From what he even states on the exhibits that I submitted, the trip was about Jaden. The only reason Friday upset me, it wasn't the fact that he went out on the town. It was the fact that he broke the trust that we were trying to build by misleading me and telling me he was going back to rest is the reason he was dropping his son off at 7:30. Had he told me he wanted to experience Nashville, it would have been a different story. That was where my trust had started breaking. On Saturday, again, he said the trip was about Jaden. I did not hear from him until 1 o'clock Saturday afternoon, where he was requesting to meet up to get Jaden. Therefore, my friend, I had to go into work on a Saturday that I normally don't work in order to make up for the day that I had missed prior. And again, he had already taken pretty much half of the day and then reaches out to me and says he wants to meet up in order to get Jaden and spend time with Jaden. At which point, when Jaden was born, these trackers that he is mentioning were not put on Jaden's stuff when he came in the picture. I sent him proof prior to where those trackers were put on Jaden's diaper bag, every single one of Jaden's diaper bags, as well as Jaden's car seat. And rightly so, because I had no idea where my child was in the state of Washington had it not been for Google and just by chance knowing his girlfriend's last name. Secondly, the money that he is mentioning me getting from my previous divorce, literally the week that this happened is literally when that money was deposited in my account from my previous marriage. Had it not been from the timing on that money being deposited in my account, I would never have been able to fly out to Washington to get Jaden back to make sure that he got a safe return with me. So forgive me for being a concerned mother to want to make sure that my child is safe with somebody that he has no idea who he is.
The father.
Thank you. What I'd like to do is understand some of these charges. Take a look here.
Michael is one active.
I'll go ahead and let you both know that my intent today is to take this matter under advisement. And essentially, I need to take a little bit more time to do some legal research into the nature of the claims and what might be a just and equitable and legally correct answer in this matter. And in order to do that, I do need to put a little bit more information on the record. And I had some questions about, there's the highlights that are in the exhibit, I believe it's exhibit F.
Honey, I'm in
court. On page 4.
Don't walk behind me.
For August 16th, there is a Fairbridge Inn charge for $307. What was that?
That was when I first came into Washington. So I ended up having to stay in 2 different hotels because my funds were starting to deplete at that point. I couldn't afford to stay at Fairbridge anymore, so I ended up getting a room to finish out the stay until I found out on Jaden at the Comfort Inn, which is later on charges that was also highlighted in there.
And how many days were you in Washington?
I was in Washington from August 15th through, I believe it was the 24th. It was either the 23rd or the 24th. It might have been the 23rd.
And during this time, were you unable to find Jaden? Is that why
I knew where he was. The law enforcement I didn't find out where he was until a few days into my stay. And that's only because law enforcement at that point, we had already spoke and we were able to find out the address that he was at that point staying at. Because the only address I had on file was his previous address, which was an apartment in Tenino.
Were you not in contact with Mr. Davis at this point?
Well, I was the day after. So I landed in Washington that Thursday. He sent me the text message, but I was not in contact with Mike until the following day because I didn't know his location and I was scared if he found out that I was coming to Washington that he would flee with my son again and I would not get him.
So you didn't tell him where you were, or you didn't tell him that you were in Washington?
I never responded after he sent me the text message saying if I wanted to come get Jaden, or if I wanted Jaden back, I had to come get Jaden. I never responded back from him until the following day, at which point the law enforcement had already stepped in because I had already contacted them and met up with them.
So you didn't let him know that you were in Washington and that you wanted Jaden back, like he said?
No, I did not. Because like I said, I was fearful that he was going to take off with my son again.
Okay.
If I could say something, Your Honor?
Yeah, let's hear it.
What I will do is I will give you an opportunity to look into this or to respond. So take notes about anything that you'd like me to know, and I'll give you an opportunity to respond after this.
Thank you.
And both of you, I want you to know, I don't want you to take, I don't want you to assume that you think that you know how I'm going to rule based on the questions that I'm asking. I am simply trying to understand the question. I will then do some legal research to determine what is the legally correct outcome. And what I'm doing now is trying to set the record and understand what is going on so that I can appropriately apply the facts to the record.
This
Okay.
is small claims court.
And part of that is I need to look at some of these expenses. So it looks like, so you've explained the multiple hotels, which was a question that I had. And it looks like you rented a car.
Yes, ma'am.
Okay. And what is the charge from 819 for $5,438?
That was for my attorney that I was retaining in order to verify that or not verify, but in order to make sure that I could get Jaden back. I retained Travis Groves as the attorney. In which at that point I still wasn't even guaranteed that I'd get Jaden back.
Charged you $5,000 to see if it's legal. I mean, yeah, that's yeah.
What is the charge at the Pierce County Library?
That is where I was printing off the paperwork in order to file the parenting plan, which I did that day.
$5,000 for an attorney, 65 cents in copying fees. These are all adding up, guys.
Mr. Davis, you can have your opportunity to respond.
Yeah, I just want to. She keeps saying that, she never asked me for my address, and I would have given it to her. So that's the one thing. She's saying that, I was hiding, I wasn't ever planning on getting him back, and that was never the case. I never said I wasn't going to return him or I wasn't going to get him back to where he belongs. So I just want to make that sure that's known.
Can I ask for your perspective on why? This may not be legally relevant, but she has stated that she believed that you weren't going to return him and that you stated that if she wanted him back, she had to fly out there. Can you have your response to that?
Yeah, after she had changed the agreement, I basically did the same thing that she had done to me. I changed the agreement. We had an agreement originally that I would fly down, she would fly back. Then I get there, she gets mad, she changes the agreement. We get back, find that there's trackers. I changed the agreement. There was no parenting plan in place. There's nothing saying you fly here and you fly here. We did have a parenting plan in place months later where it worked out that, and there was no issues where, I would fly to get him and I would fly to return him. There was couple times where she flew out one way, but most of the time it was me flying both ways. That was in a parenting plan and agreement. That was all set in stone. So that's how that ended up. There was an original agreement. She got mad. She changed it. I got mad. I changed it. And now she wants to blame me for her losing her job and stuff when she obviously never had, and it seems to me that there was never anything in good faith with her, because it seems to me that she never planned on allowing me to return to Washington with my child, nor did she, ever purchase the ticket ahead of time, because he was going to be there for, I believe it was a week. So, she should have already had that ticket purchased to return to retrieve Jaden. So it just makes me. I bought my ticket to go see my son a month and ahead of time before I was supposed to go see him. I knew when I was going. I had the hotel booked. I had plane tickets booked. I had a rental car in place. This was all a month before I was supposed to go pick up my son. She had nothing in place to come retrieve him. Nothing at all. So there was never intent for her to come and retrieve him. She was never going to let me leave Tennessee without him, because if you're going, a normal person, if they're going to go retrieve their child, they buy those tickets ahead of time. Just like every time in our parenting agreement that she had to come out and retrieve Jaden, she had bought those tickets more than a week in advance.
So I'm trying to understand here. So there was the initial trip where you flew out to Tennessee, and then did you take Jaden back to Washington with you?
I took Jaden back to Washington with me, yes. Yes.
And at that time, the understanding was that Ms. Ruley was going to fly out to pick him up.
No.
Yes. Yes. And then prior to the Sunday of me leaving, Ms. Ruley then changed it to saying that she didn't have any money, she couldn't afford to go. If I was going to have any contact with my son, I would have to buy a ticket. So I said, fine, I'll buy a ticket. But my thing is that she had never planned on ever giving me.
So then you
doing
agreed,
that because
you agreed that you were going to take Jaden back.
I told her I would, yes.
You told her that you would. And then
like she told me that she would fly out originally.
So originally she said she was going to fly out, and then you said that you were going to fly out, and then you found the trackers, and you decided that
she needed to fly out to get them.
Okay. What okay. I think I understand. This is what I'm going to do. I mentioned I was going to take this matter under advisement. What I'm going to do is I'm just going to take a brief 5 to 10 minute recess, think through what you've told me, do a little legal research, and then I will return to the bench, and I will be either delivering my judgment, or I will take this matter under advisement for longer to ensure that I can provide the legally correct result. Okay.
Is there a chance I can say one more thing prior to you going into break?
Oh, sure.
Yes, you may.
So when the agreement changed strictly because I was concerned for Jaden to be in the presence of a stranger, basically. When he agreed, if I was never going to let Jaden go, I would have never let Jaden go that day that he flew back to Washington. I had spoke to the courts here in Tennessee. I had spoke to local law enforcement. Multiple law enforcement agencies were telling me they advised against it. But being a mother wanting to have my child's father involved in his life, I still allowed it to happen. And there is the agreement, even if I don't know of any mother that would honestly let their child go with a complete stranger, not just to the bordering state, but across the country. And prior to that, as far as the addresses go, I never asked for his address, and I never pushed for his address because I never even had any idea he had moved.
But you had trackers.
All he had ever given me for any type of communication was a P.O. box. That was it. So therefore, I was not comfortable with my son across the country not knowing where he was at or how to get in contact with him, with me being at that time the only one that was providing insurance for him if something were to have happened to him.
Okay. So one more time before I step back, let's see if there's, so initially you said that you were going to fly out to Washington to pick him up. Then while he was in Washington, you didn't have the money to pick him up. So you asked Mr. Davis to return him, and Mr. Davis agreed. Is that right, Mr. Davis? You agreed to return him initially?
I said I would, yes.
Okay. And then you changed your mind, and then you said that you wouldn't. Okay. Just want to make sure I understand the.
Yeah, Mr. Davis, that's a verbal contract you just agreed to.
Anything else from either of you before I step off?
Yeah, she never told me she was coming to Washington to pick him up, and that was that would have been a different conversation probably. But she decided that she just wanted to show up and do these things. So, I mean, if she would have originally just had her plane ticket scheduled and bought and paid for, she would have been okay. But it doesn't seem like she even had that in place. So
I didn't have it in place because I was the only one providing for the child at that time. I did not have the funds.
So you're gonna buy it. You're gonna buy it the week that I had it.
Not to be having an argument on the record. The purpose of this is for me to understand what happened in this case, not for either of you to be arguing with one another. So with that, I will take a brief recess and I will return to the bench.
So let's see. Let me go back here to our speed. Turn it back to normal. Speed is normal. And let's see if she came back.
And I will return to the bench.
Yeah, you're going to return to the bench. Go to channel. Oh, she's back. She's back.
Fence.
Let's rewind and see what she did when she returned to the bench. Just the right one. Yeah, that's the right one.
Mr. Davis, Ms. Ruley?
Yes, ma'am.
Okay. Thank you for that time. What I'm going to do is I've requested some information to be brought to me. And so that's going to take a little bit of time. So what I'd like you to do is, court is largely a lot of waiting. So I'm going to take up another matter. And so just hang tight and hopefully we'll be able to resolve this for you today. The other option is I would need to call you back in a week or two to deliver my judgment. And I suspect that you would prefer to hear something today.
Yes.
So go ahead and mute yourselves and turn your cameras off and I'll take up another trial.
Now, do you want to listen to the other trial, or do you want to just see if we can find the find the next one?
We will be on the record with case number 39360, the case of Randy Vickers versus Patricia Heitzman.
Hello, Pat. Welcome, Rainey. Good to see you both together again. No, I guess not really together.
Yes, ma'am, I'm here.
Good morning. I will go ahead and swear in the parties, and then I'll hear from the plaintiff, followed by the defendant. And then the plaintiff will have time for rebuttal if you would like to take it. And as you saw, if there is further information that the court needs, I will ask for it.
They witnessed this last case.
Mr. Vickers, if you could raise your right hand.
Don't do the Vickers.
Do you solemnly swear or affirm the testimony you're going to give today is the truth and nothing but the truth?
Yes, ma'am.
Yes, ma'am.
Okay. And Ms. Heitzman, Patricia Heitzman? Okay, and who do you have with you?
My daughter.
Debbie.
Gabby, will you be delivering testimony today? Okay, please also raise your right hand. Do you solemnly swear or affirm the testimony you're going to give today is the truth and nothing but the truth?
Yes. Yes.
All right, Mr. Vickers, you can proceed.
You're all under oath. Keep it truthful.
Alrighty.
Like
This goes back to,
the lanterns behind it.
let's say, summer of 2024.
Ooh, take me back.
Attempted to
The good old
contact
days.
Ms. Heinzman by email. Got no response, so I called her and I had spoke to her in regards to the fence that divides our property, her income property,
Okay, so
and
they're
my home,
neighbors.
and that I would like to address replacing it perhaps next summer, which would be the 2025. And she said she'd be happy to discuss that with me then. Come 2025, I reached out via email first, then attempted a few phone calls. And at one time, her daughter Debbie did answer the phone and told me that she had no knowledge of any of these emails and that I would have to call back and speak with her mother, which I attempted to do approximately 3 times, and then began the string of emails in regards to the fence. I did get a couple responses.
The string
They
of
claimed
emails.
they came out and shook the fence, didn't find any rot or anything. After that, all my attempts to contact and have a conversation with them were during part of the responses of the emails, I was told to take up my issues with the tenant, and it clearly shows that in the string of emails. But this is ridiculous why we're here.
That's the case for most small claims courts.
So anyhow, after several attempts to at least get communication, there was nothing. I got frustrated. I figured there's got to be a lot of this. So I started researching RCWs. I came across RCW 16.60.010 through 095. Okay. And it clearly states in there to do your best and due diligence to resolve issues with your neighboring property owners, which I feel I have done by emails. The proof is all there. My concern was the rotted fence that was in total disarray. There's approximately 15 pictures plus that I have posted here. I don't know if you've had the opportunity to look at them. This fence is clearly rotted. Ms. Heinzman and her daughter will contend that the rest of the fences on my property are all beautiful and newly constructed, and I just needed to complete this fence.
So, Ivan, this is not
That's
family
not
court.
true.
This is small claims.
Facing my home
Both
on the
of
right
these.
side of the property, 16 foot is a wooden fence. The back 50 foot was put up by the neighbor next door, 50-foot chain link fence. The back of the property, 70% chain link fence, which belongs to one of my back neighbors. The other one is approximately 30% wood fence, 6 foot in great condition, belongs to back others. So this has nothing to do with wanting to beautify my entire property. This has got to do with a fence that is simply rotted, not maintained, requires replacement. Now, according to the RCWs, everything that I had done fallen in there. I had originally provided Ms. Heitzman with 2 proposals, one from another fence contractor local here, and another one from myself. At that time, I was doing business as the guy, the general contractor, which I fully disclosed that information.
I'm the guy.
When all said and done, and not getting any more response, I felt I needed to proceed. My worst case scenario is I'm going to be stuck with this whole bill. So I've done everything I possibly could to negotiate further discounts. I even shopped cheaper fence boards, and I brought it down another $900. So when it's all said and done, I provided Ms. Heinzman with before pictures, during pictures, and after pictures, along with invoice for 50% of the cost, $1,500 and bear with me 1 second here.
So you replaced the fence between your properties, and you want her to pay half of it. You were the contractor on the job. She never agreed to replace the fence. You say it was rotten. They say it was not. Not seeing. Might have to prove. I don't know. Let's see what the law says.
Open up here. There we go. 15% was $1,519. That is a total savings of $900 from the original proposal. I couldn't bring it down anymore. Couldn't be any more fairer. This is not about attitude, vengeance, or anything like that. I've never met Ms. Heinzman. I've spoken to her once back in 2024 and attempted to rectify all this without being here.
But here we are. All right,
Mr. Vickers, may I ask a question?
Certainly.
Whose property line is the fence on?
This is an important one.
As far as I understand, is down the center. So on both property lines.
Okay. It's a shared fence. Okay. If it were on his property,
and
it would
remind
be
me
his
again
fence.
of what the total cost was to replace the fence.
Total cost was $39.06.
And did I hear you right that you that it was your company that did the work?
No, ma'am. I pulled this all away from the company and just reached out to some other individuals that have done work for me and basically told them, hey, this is where I'm at. This is what's more than likely going to happen. Work with me here, please. Okay. And they came in with the cost they did. I provided the materials because I shot my contractor discount on the materials.
Okay. So it wasn't that you did the work. You were just able to get the materials for cheaper because you're a contractor.
Yes, ma'am. The labor came in cheaper as well. I assure you that.
Whose labor was it?
How many feet is the fence?
It's 70 foot of shared fence, 70 linear feet. The cost breaks down less than industry standards as well, even on my original proposal.
Man, I miss my fence. Okay. My fence buddy passed away.
Anything else you'd like me to know?
I'd call him up and
yes, this is Miss Heinzman's income property, one of 14 she owns.
Oh, so you're entitled to her paying for the fence, apparently.
Is it Heitzman or Heinzman?
It's Heitzman. There's no N in it.
My apologies.
I just want to make sure I'm saying it correctly. And who would like to speak?
My mom has asked me to help her with this. She had a stroke this year. She's been hospitalized, and so she has all of us siblings stepping in to help her with things. She asked me to help her with this.
Okay, go ahead.
Let's hear.
So my mom did show me the email from Mr. Vickers complaining about the fence and proposing a replacement. So her and I both drove out there to the property and went onto the property through the gate to the backyard, tested the fence. I tested it in multiple locations over about a 30-foot section of it, and I couldn't get that fence to budge. It did not shake. I'm strong. I'm I was shaking it as hard as I could, and it didn't shake. So we actually came back to my mom's house right away, and that same day sent him a reply. This was 4th of July, and I replied to him on my mom's behalf saying, hey, we tested the fence. It seems very sturdy, and we don't think there's any reason to replace it. And he did reply back that same day saying that there was at least one rotten post in the back corner that we must not have noticed. And it's true, I did not go back to the back corner, but where I did go was to the middle of the thing and try to shake it, and it didn't move. And he said that if we wanted to just replace the parts that needed replaced, that he would look into that. And we told him to go ahead and look into it. And that was in, so we had 2 email exchanges, and then I never heard anything more about it. I've never spoken to Mr. Vickers. He has not talked to me on the phone. My mom says she has not talked to him on the phone. And I'm unaware, if you read my statement to the court that I filed as evidence, I'm unaware of any further emails from Mr. Vickers. I honestly thought this was a dead issue. I thought that once we said, hey, the fence seems stable, that nothing else was going to happen to it. My mom is unaware that this was a continuing issue going on. If you read my mom's statement to the court, she did dictate it to me, and I typed it for her and submitted it. She has concerns with the price that he's charging. She does own several investment properties, like Mr. Vickers stated, and has replaced many fences in her lifetime. And she has issues with the price that he's charging. And I can tell you that when we pulled up to the property, it is very obvious when you pull up to the property that his backyard was fully refenced and looking beautiful on 2 sides. And the third remaining side, which was shared with my mom's property, was the only piece that was still old, ugly, and worn. And it is old, ugly, and worn, but it was sturdy. And so basically what the email said is that maybe it'll need replaced at a future time, but it doesn't look like it needs replaced now. And if you look at the photos that Mr. Vickers submitted, he did submit a lot. You don't see in his photos any actual rot. You do see rot on the inside of some of the posts that are in his debris pile in his trailer. But I can tell you, like, I even used some of his photos in our evidence because there were at least 2 photos that were a close-up of what still remains of my mom's fence, that is the gated portion. And if you look at those photos, you can see that it's old, it's ugly, it's weathered, but the top of the boards and the bottom of the boards are still just as cut, just as true as they were the day that fence was built. In my mom's opinion, it didn't need replaced. And I'd like to close by saying that Mr. Vickers did not have permission to take any action on this. There was no agreement in place. He trespassed on our property without permission. He dug up plants without our permission and removed stuff from the property without permission. All of that happened because you can tell if you read the email chain that he submitted the email chain, we submitted the same email chain. He left one email out. Everything's in ours. You can see that his frustration rising, and that he just says at the end, he says, well, since you're not replying, I'm just going to go with my original plan and build the fence the way I want to build it. So he just did what he wanted. And his property is beautiful now. All 3 sides of his backyard look beautiful now with a beautiful fence. Meanwhile, he expects my mom to pay for it because he wanted his yard to look pretty. It is a gorgeous fence. There's no denying it is a beautiful fence, but whether it needed done or not is what's in question. And there was no agreement in place for my mom to pay for any part of that.
And from your perspective, whose property is the fence on?
I agree with Mr. Vickers. It's probably straight down the middle. I would think that that's probably true. I don't know it any different.
And the pictures that are in here, whose property are they taken from?
That is those pictures, the pictures that Mr. Vickers submitted a lot of pictures. I just submitted 1 page of pictures. It's Exhibit D on our evidence. And there are 2 pictures involved, and those were taken by him standing on our property taking.
Trespassing.
That's a picture of the gated fence that we
Evidence
went
of
through to
trespass.
get into the backyard to shake the fence and see whether the fence needed replaced or not.
All right. Unless the evidence shows the fence was in bad condition, I think they might just have to split the cost of replacement of one post. If I were the judge, I mean, how would you rule on this one? Let's all put on our robe here for a minute and decide this one based on the facts.
So the picture in Exhibit D, I'm just trying to understand. That fence there with the gate, that's on your mother's property.
That's correct. And it's a true representation of what the fence looked like. It was old, it was weathered. And that is what the fence looked like that he removed. It was built at the exact same time that the side fence was built.
And then when I look at the second photo, there's a little tent, and then that fence back there, that's the fence line between the two homes.
Correct.
Okay.
There's a little tent.
And Mr. Vickers, the photos that you submitted, were those were from your side of the fence?
Yes, ma'am. Also, some of them from their side. Now, as far as trespass goes, as you can read in the emails.
Oh, I'm not concerned about trespass.
Okay, well.
That wasn't the purpose of my question. I'm sorry to cause alarm. So when I'm looking, let me ask my question, and then you can let me know what you want to know. Okay.
Yes, ma'am.
So when I'm looking at this fence, I'm looking at, I think it's the first photo that was submitted. There is a concrete pad, and then there is the fence that I think is in question, and then there's a chain link fence. Is that?
Okay, this is my exhibit, correct?
Yes.
Okay, let me get to that picture.
Scrolling.
All right. Yeah, that chain link fence, that's the back fence, which belongs to neighbor behind me. Their chain link fence runs for approximately 70% of my backyard. The other 30% belongs to another back neighbor, which is a 6-foot wooden fence in very good condition. All right. The fence to the right of me, which is not shown, 50 foot of that is a new chain link fence put up by the property owner there, which is also a rental property. And the front 16 foot I put up in agreement with him putting up the back and me hauling off all the old fence. So therefore, as far as my right property goes, it was all negotiated amicably between myself and the property owner there and taken care of as agreed. I'd done more than attempted to communicate with Miss Heidsman in regards to this fence. And it left me no other option than to resort to the RCWs.
We need to hear these RCWs.
I mean, the fence is it's rotted. On the other side, you'll see cinder blocks, which were covering holes from that side. In the front section of the fence, there was a pallet on their side that covered missing boards that were broken off. The back section was fallen over. And if you look at the back where their chicken coop is, which there's about 8 chickens roaming back there, when once in a while one would crawl through the largest hole in this fence. But anyhow, if there's any indication, it's the back fence of that property, which I don't know which photo. I'd have to sort through here.
The judge isn't going to know either unless you do.
I'm looking at what appears to be the last photo that you submitted.
Revised Code of Washington is RCW.
And it's a picture.
If it's the chain link picture of the backyard, my mom has deliberately not repaired and maintained that fence because there's a chain link fence there. It really doesn't
that's
represent.
not what I'm asking about. Okay. And I'll give you a chance to respond, okay?
Okay, I'm on the very last picture, second page.
It looks like the one I'm looking at, there's a new fence. There is a tent. And so it looks similar to
the chicken coop.
That's the chicken coop?
Yeah, that's their tenant's chicken coop.
Okay. And then behind that, is that the fence that's at issue between your property and Ms. Heitzman's property?
What you see in this photo is the new divider fence between the greenhouse and their property to the left. I'm in the green and they're on the left.
Okay. So that's the new fence.
Yes, ma'am. Yeah, that's replaced. All the photos of the fence that looked like before it was removed. And what I had done, I had negotiated as low as I could go. And if anybody really thinks that you can have 70-foot of linear fence done for less than $3,000, please show me.
Gabe, we got a poll up right now.
Okay.
You be the judge.
And as far as the posts go, Your Honor, a couple of the posts were wobbly. The far back one was broken out. And upon removing all the other stuff, there's also photos of posts with damage that were covered up by the dirt and stuff. Okay. Bottom line is, my philosophy is if you're going to do something, you're going to do it right. I didn't want to have to contend with having to pay for this another couple of years down the road when those posts ended up rotting. So therefore, do it right the first time. Keep the cost down to the minimal, and that's exactly what I had done. It can't be done for any less. And once again, I'm citing the RCWs, and RCWs in my state that both parties are responsible. And I know that it states in there that we're to resolve this stuff amicably before going to the courts, which all the emails, I done my best. I didn't know what else to do, so that's why we're here.
Ms. Heitzman, it appeared that you had something that you wanted to say. Is that
Debbie?
Related to what you thought I was asking about, or is that something else that you'd like me to know?
No, sorry, I don't have the photos up, so I'm not sure what's being shown in the photos, that's all.
Okay, yeah, it was not related to a chain link fence. Okay.
Your Honor, when you were in judge school, did you ever think one day I'll be sitting
ready
here
to
deciding about a
make a
fence between
ruling.
two neighbors?
Give me one moment here.
One day I'll get to decide who gets the fence and who pays for it. Do we need verdict music? This is tamed for the courts we watch.
So this case involves
She's
what
gonna
I've
sum
been
it up
calling
for
the
us.
law of fences, chapter 1660, which regards partition fences, and specifically partition fences that are erected between two neighbors that are directly on the property line, which is why I was asking about that. Both parties have agreed that the fence line goes directly between the two fences, or excuse me, is directly on the property line between the two properties. And RCW 1660-020 states that when any fence has been or shall thereafter be erected by any person on the boundary line of his or her land, and the person owning land adjoining thereto shall make or cause to be made an enclosure, so that such fence may also answer the purpose of enclosing his or her ground, he or she shall pay the owner of such fence already erected 1/2 of the value of so much thereof as services for a partitioned fence between them.
Ooh,
Now
the law's in his favor.
The language of this statute seems to contemplate a new fence being built as opposed to replacing a fence, but I think that ultimately the result is the same, that a fence has been built between the two properties, and the law contemplates that the two neighbors shall share that property. I have heard testimony today from Ms. Heitzman's daughter with regards to their belief that the fence was not in need of repair, and I have carefully reviewed the material submitted by both parties. In looking at the fence between the two properties, it does appear to me, and again, please hearken back to the information, to the speech that I gave at the beginning of this. I was not there. I do not see it in person. The best that I can do is based on what is in the photos. In examining the photos and listening to Mr. Vickers' testimony with regards to chickens coming through the fence, it does appear to me that while the fence is in some places sturdy, that it does appear that in some places it has rotted out, and that thus it was not unreasonable of Mr. Vickers to replace the fence. It also appears to me that based on there being 70 feet of fence, that the cost of, I believe it was just over $3,000 for replacing that fence is a reasonable cost. And while I do understand that Ms. Heitzman or Mrs. Heitzman may disagree with this, it appears to me that based on the law, the statute that I read aloud to you, based on the photos that I have seen, that Mr. Vickers was not acting unreasonably. His standard of proof is not the same as a criminal trial where he needs to prove this beyond a reasonable doubt, but rather he needs to prove it by a preponderance, which is merely 51%. And it appears to me that he has done that. I will therefore be signing an order in favor of Mr. Vickers for half the price of the fence.
He gets half.
Thank you very much.
It's like a neighbor divorce.
My court fees too, please.
You don't get court fees.
Let's see.
You get court fees as well?
Yes. What are the... Let me get this.
The results. 47 of you sided with Mrs. Heitzman. 27 sided with Home Depot, who's the ultimate winner. And then Mr. Vickers had 26% of the vote. So judge goes with the minority decision here, at least from our chat, and awards the split down the middle with court fees added.
So the principal amount, I believe, if I have that written down right, is $3,039.06. Is that right?
That was the original amount, correct?
Okay, so we're going to divide that in half.
I got 1519.53, Judge. 1519.53.
Half of that is $1,519.53.
Yes, my math checks out.
And what was your filing fee and service fee?
$75, $35.
Filing fee was $50, no service fee.
So we'll add $50 to that. That brings it to 1569.53.
If I may ask a question, please.
Yes, sir.
I'd like to know how I'd be able to reach out to Ms. Heitzman so that we may have communication so this does not go any further and become more financially involved.
It's my understanding that you have her email address.
Well, apparently they don't read those emails.
Mrs. Heitzman, would that be an appropriate way for, again, I'll ask you to harken back to the speech that I gave. You know, this now enters. You've done the easy part of obtaining your judgment, and now you need to
do the hard part
enforce that judgment. So, but I do think perhaps you could agree by email or by mail to correspond, or if you would like to exchange numbers, that I'm going to leave that up to you, but I'm not going to include that as part of my order.
Emails would be fine.
Thank you very much.
Thanks, Pat.
Okay. Signing an order in the amount of $1,569.53.
Judgment for the plaintiff. Now, can we go back to our other case, Your Honor?
With that, you are free to go. My understanding is you can get a copy of this order.
Off our website.
Yes, off of the website in 1 to 2 days.
Yeah, I would say before. By Monday.
Most likely by Monday.
Thank you.
Thank you.
Thank you. Okay. I am going to take a brief recess. It appears that there
We're still here.
is at least, I'm guessing, one other hearing today. Okay.
Then you decide the other one. So now let's go see if she's come back from her recess. Okay. And she's not back yet. She's not back from recess. All right. Wow. Deep breaths, everybody. Just calm down. Just calm down. Thurston County delivering in the small claims court little bit of excitement. Let's see, courtroom 4 has nothing. Courtroom 1 has nothing. Courtroom 2 has nothing. Oh, courtroom 2 is live. Let's go there.
Your next court date is going to be trial confirmation. Is that March 20th date still pretty open? Okay. March 20th will be your next court date for trial confirmation on both of these cases.
I think Travis is passenger.
That's going to be at 9:30.
Because they don't have that.
And then your trial dates are going to be March 30th and March 31st.
So the newbie judge.
The important date to remember is that March 20th at 9:30.
Yes, because
and
that's
then
4
we'll
days
print you
before my
off.
birthday.
Since you're here, we'll get you your paperwork here with the next court date on it. All right.
I don't live in town. Just a bit of a drive.
Is that Willie?
Are you saying that because it's difficult to get here earlier in the morning?
Well, just yeah, it's like Hoquiam.
Okay. You're also allowed. I don't see any notations here about physical presence. You're allowed. Do you have access to Zoom?
I just I think I just downloaded it just now. I was like,
okay,
it sounds like it's probably a good idea.
Yeah, I mean, if transportation's an issue, you're allowed to attend on Zoom unless the judge tells you otherwise. And I don't see any notes in your file indicating that that's okay. An issue. So, yeah, you're allowed to attend on Zoom as well. But we'll get you that paperwork here today with the next court date on it.
All right.
Travis' significant other has a question, Your Honor. If you can recognize her, she's been raising her hand. You need to, and she's driving, so she needs both hands. I'll keep an eye on Thurston Court 3 for when we come back for the decision on the plane ticket case as well.
Thank you. Good luck, sir. Okay. Miss Rowe and Balzer, have they been able to
Miss Rowe? Hey, Miss Rowe.
No.
Long time no see.
I've been asking. Miss Bozo, can you hear me?
Miss who?
Balzer? Yeah.
Bozo?
Balzer?
Oh, no, yeah, we are talking about your case. Miss Rowe's trying to address Maria Bozo at the public defender's office. She coordinates that's okay. No, similar sounding names. She coordinates the breakout rooms on Zoom. Are we able to?
I thought you were calling me a bozo.
I know that's not really your job. All right, we'll get you in a breakout room here. All right. And then while that's happening, Ms. Moore, do you have folks you're able to call?
I mean, we can run through the FTAs at this point, Your Honor.
Okay.
Hey, Ms. Moore.
Yeah, so
Happy New Year to both of
Chambers
you.
number 1.
As Dirk's client, no representations.
Jamie, OG, 28 months.
Like there was some issues with summons in the past.
Happy New Year's, everyone. OG. Thank you, Jamie.
Did update the address in October.
They would request a $2,500 warrant. There's been prior warrant history in the case. One warrant was $2,500. So.
Austin Chambers.
Perhaps it's French. Bozo. Bozo. Merci beaucoup. Bozo. What is this case about? I'm not sure yet. We're still trying to find out. We want to go back and hear the final outcome for the plane ticket case.
Yeah, there's been
Tennessee
a lot
to
of
Washington.
Warrant history in this case, so I think at this point, $2,500.
It's amazing how many times those two states come up together in civil cases.
Chambers.
We had the furniture damage was also a Tennessee Washington issue. Also,
Right. Next we have Brian Muller.
Your Honor, standing in for counsel of record, Ms. Myers, I would ask the court to waive his appearance under Rule 3.4. I believe there's a signed waiver of speedy trial in the judge's folder. Sorry, this one slipped my radar to call earlier.
Sorry. All right, looks like Brian Muller's got bail posted. Or looks like this would be a second. Any notes as to the reason for a second waiver?
There are a few things they're still working on. I know Ms. Myers, I think, is just back in the office for the first time in a week today after she got trapped in Pennsylvania.
Trapped?
But,
Sounds
also,
like a
I
Brian Koberger
think
film.
based on the incident date, this is likely the first such request.
Okay. Yeah, I agree with that.
Trapped in PA.
Okay, looks like bonds have been posted. There's an ignition airlock device. Not seeing any violation reports of that. Okay.
It did
All right,
snow a ton.
So we'll go out to.
This one goes out to the one I love.
I forget which sixth is filling up.
Thurston 3 is back. Okay. Thank you, Josh, for the immediate heads up. We're going to catch this one live. Going back to 3. Ready? She's back.
I can only make what is illegally.
Wait. 2 minutes ago.
In this matter. So the primary question that I wanted to ask and to determine was whether small claims is the appropriate forum for this, given that this is
family case.
Really a parenting plan, family law issue. One of the things that has decided this for me is the fact that there was no parenting plan in place at this time that I would hope would otherwise include information about transport for the child, times for visitation, who will do the pickup and drop off, things like that should be ironed out in parenting plans. In this matter, because there was no parenting plan, it appears to me that if anything, this is a contract issue. Contracts can be in writing and they can also be verbal. In law school in the very first year, one of the things that we learn about is what constitutes a contract.
Mike's out.
Contract involves an offer and acceptance and consideration. And the primary thing that they instill in us is to ensure that there is a meeting of the minds between the parties. Without a meeting of the minds between the parties, there can be no contract.
I don't think he
I
has to
heard
pay
quite
for
a bit
a lawyer,
from
though.
both of you about what happened in this case with regards to initial agreements, changing the agreements, going back to the other agreements, going back here and there. And it seems to me that there is quite a bit of strife between the two of you with regards to your child.
A wee bit.
And I think that both of you certainly have reasons for feeling that way. It is very emotional to be a parent and to care for the safety of your child. That is one of the things that is of the utmost importance. It appears to me that there was no formalized agreement with this. And due to that, there is no basis in small claims to enter a judgment in favor of the plaintiff. Now, Ms. Rulli, I do absolutely understand why you took the actions that you took. You were acting for the safety of your child. It appears that there was certainly some disagreement between the two of you with regards to what would happen. And it appears that perhaps with both of you, there may have been some sort of gamesmanship between the two of you in terms of what could have happened, should have happened, and blame going back and forth. I hope that you both listened carefully to the speech that I gave in the beginning when I said that I cannot make an agreement based on what I think is right, what I think is fair, or what I think is morally correct or right. If I were allowed to do that, I can't say that I would make a different agreement, but those opportunities are foreclosed to me. I can only make what is the legally correct decision in this case. And in this instance, I can't make a decision about who acted rightly or wrongly. I can only make a decision based on what's legally correct. And it seems to me there was no meeting of the minds between what was supposed to happen. And Ms. Rulli, it is your burden to meet this by a preponderance of the evidence, and I'm unable to find that you did. And that is my judgment.
Case dismissed. Now please work this out for the benefit of the child, because if this continues on, It's just bad news.
I will continue to take care of our son by myself. Thank you.
I do hope that there is hope for what can go forward, which is to ensure that there is a parenting plan between the two
There
of you.
is, and I've got full custody, and the state of Washington's really failing me, but I appreciate you wasting your time. Thank you.
Okay.
And she's gone.
Thank you, Your Honor. You have a great day.
You are both free to go.
Oh, she's gone already. Wow. State of Washington's wasting my time. She has full custody. Michael, quit being a slacker. Pull your weight. It's your child. You're halfway responsible. So legally, you're not responsible for any of the fees that she racked up coming up to Washington. But as the padre familia, what's the padre from, as the father.
That I believe we're going to what I think is the final trial for today, which is, I'm guessing it is 39406, Fernando Garcia versus Simply Home Realty.
Hey, Your Honor.
Hey, Fernando. It's a nice chair. You're suing, we've got two for Simply Home
Here's
Realty.
we have Mr. Garcia. You can raise your right hand. Do you solemnly swear or affirm that the testimony you're going to give today is the truth and nothing but the truth?
I swear.
And on behalf of Simply Home Realty,
You've got the boss and the lady who does all the work.
we have Ms. Allison, and I can't read my own writing. Olson?
Yes.
Okay. And it appears there's someone else on the line for Simply Home Realty.
Mm-hmm.
He's nodding.
Is that Mr.
like a bobblehead.
Eugene Kyan?
Ian.
Yes,
Ian?
Your Honor, Eugene Kian.
Okay. Will you both be presenting testimony?
We would love to.
Okay.
If we both can speak.
Wow,
Okay, raise your right hands.
Other right.
Do you solemnly swear or affirm the testimony you give today is the truth and nothing but the truth?
Do.
I do.
Fernando.
All right, Mr. Garcia, I'm going to give you some time to present your case.
Fernando didn't swear.
And then I will give the defendants a chance to speak, and then I'll give you a chance to rebuttal. And as you have probably observed, I do ask questions, and I do allow additional time to make sure that everyone feels that they are heard. So with that, however, we do have, I believe, only until, is that 12 noon?
Yes.
Okay, at which point the clerk does need to take a break. So please keep that in mind, and we would need to come back after. Are we able to come back after lunch?
The clerks union is strong in Washington.
Okay.
So, please wait.
At that point, we would be done for the
Okay,
day.
my hope is that we can resolve this relatively quickly. So far, the trials today have been going relatively quickly. Mr. Garcia, please go ahead.
Your Honor, this case is about whether the money taken from my security deposit was fair under Washington law. I am not arguing about timing. My issue is that most of the charges were for normal wear and tear and regular turnover cleaning. The landlord charged for things like scuffs on walls, small marks from stickers, pet hair on baseboards, and general cleaning. These are normal after someone lives in a home and are part of preparing the next tenant. I received a check for $377, but I never cashed it. I tried to settle this before court, but we cannot come to an agreement. I'm asking the court to decide what deductions, if any, are fair, or to order the return of the rest of my deposit.
Okay, I'm on Garcia's side just because he was just factual. Can we have everyone do what he does? But take the oath, which the judge swears he in. Do that. But then other than that, just keep it succinct. This is why we're here. Keep the drama out. Here's the cause.
Okay. And who would like to speak for Simply Home?
We feel like the charges are accurate and legal, based on, we uploaded a couple hundred photos as proof. The home was freshly painted, just a few days before the tenant moved in a year prior to vacating. The let's see. So we feel like, if there had been a couple spots here and there in the home for the walls marked up, we wouldn't have charged them. That would be normal wear. It's every room throughout the house. There's a lot of dark areas and scuffs and dirty, and it was just excessive amounts to be calling it normal wear for just being painted a year previous.
And am I right that the security deposit was $4,312.50?
Yes.
What? How much was rent?
There was the charges for painting, carpet cleaning.
Is this a business rental? Like corporate?
Landscaping, anything else?
Yep, there was repairs, cleaning, landscaping, and the carpet was only the enzyme treatment for the pet, not the actual carpet cleaning.
Landscaping from a security deposit?
What do you mean by that?
Did he like
the enzyme cleaning? It's not, you don't consider that carpet cleaning?
So the owner pays for the carpet cleaning according to the law. And the enzyme treatment, it is an additional charge. And a tenant that has a pet is charged just the enzyme treatment fee, not the actual cleaning. The exhibit 13 on ours is the carpet cleaning invoice.
Which exhibit? I guess I should ask Mr. Garcia, which is the exhibit that's the lease? Or did you provide the lease?
The lease agreement was, I believe, I'm looking for it, I'm sorry.
Man, $4,000. I'd be ticked off too if they took landscaping fees out of my security deposit for a rental. Unless I parked my truck on the front lawn and did donuts until the truck was buried up to its axles. You'd have to do some serious damage to the landscape, I think, to take out a security deposit. Even if the grass died while you were there. Bill Stubby, are you here?
I don't think I uploaded the lease agreement, Your Honor.
That's court 101.
Did you include the lease agreement, Ms. Olson?
We did.
Oh, good. At least one of you got it.
It's the exhibit 1 on the first page.
There it is.
They took
I did review
$700 out.
To be clear, I did review all of the files for all of my cases today. But after the exhibit numbers kind of blur together.
Oh, I'm sorry.
Takes to mean that I did not review the. Where in the lease does it say that the enzyme cleaning is to be deducted? Can you point me to that, please?
Yeah, just 1 second.
If it's in the lease, it's the law.
I think that's actually going to be in the pet addendum. Sorry, not the lease.
Could you include the pet addendum?
We have a separate document for the pets.
Separate from the lease? You should have a signed pet addendum, then, right? Yeah, we're going to get to the landscape.
So paragraph 4 in the pet addendum for cleaning.
Dude, how much is enzyme? How much is saving the Google? How much is enzyme treatment for
Looking
carpet?
for the pet addendum.
Oh.
Where is the pet addendum?
Okay. It's not letting me load this beyond the first page. I'm sorry. It's going back to a blank.
It's pulling up to a blank document. Well, I guess there's no agreement then.
See an exhibit A for tenant charges. Exhibit B, move out cleaning checklist.
Mrs. R.A. just did her first
Exhibit
new
C is an
student
insurance
onboarding
addendum.
meeting.
Exhibit D is a smoking policy addendum.
So there's an extra uploaded exhibit for the pet addendum. I'm sorry. That's what I was trying to find for you, where it's at on the list. And it's going back to the main blank
Pet
page.
addendum. There it is. Okay.
The landscaping's got to be expensive. I asked a landscaper that works in my neighborhood how much it would cost to just tidy up my yard a little bit. Just, trim the bushes and trim back the trees and edges and all that. Yeah. I'm not getting another mortgage to pay him. Apparently that lawnmower runs on pure liquid gold. He wanted like $1,400 to do my yard. Once. I'm on
Can you point to me where in the pet addendum it says, let's see, cleaning?
0.7 acres.
Yeah,
So that's the
paragraph
thing, I
4.
don't see it. Apology, what's that?
Paragraph 4 is for the cleaning.
Gallon of concentrated enzyme cleaner can cost $20 to $60, says Valerie. I'm sure there's an application.
And then there's also in our move out cleaning
120.
checklist, in the lease, it does also say that if animals were present on the premises, the tenant will be charged for enzyme treatment at the time of professional carpet cleaning.
You got 6 minutes to decide this, Judge. Make it happen. I would hate my job of being a small claims judge. Are they appointed to that? If I wanted to be a judge, this would be the last area I would want. It's got to be appointed, right? Do they have a choice? I think you get what you get, right? You apply to be a judge in an area, and they assign you. And basically, as you have more and more rank, you get more and more important cases, or you get more and more say over your docket, I guess. I think that's how it goes. When you start out, you're here in small claims.
Did you have anything else you wanted to say?
When it comes to the enzyme treatment,
I was asking Ms. Olson real quick. Don't worry, I'll get back to you. Just remember what you wanted to say, and you'll have a chance to enter what's called a rebuttal.
Yes, Your Honor.
Okay. Anything else from you, Ms. Olson?
I don't think so. We're just kind of disappointed in, to see the condition of the home after only being there for a year.
So no review.
I'm sorry, was it Kian or Kian?
Kian.
No referral letter for his next.
Mr. Kian, anything from you?
Well, we tried to discuss it with Mr. Garcia. We scheduled a Zoom meeting with him earlier this week, actually last week. Oh, maybe this week. And we tried to explain and reason with him and address his concerns. We spent more than an hour in the conversation, and we showed him the proof, and we uploaded all the proof to the court files. The claims are outrageous, honestly, because the condition of the house, if you go through the pictures, you will see that it does not qualify as normal wear and tear. We've been doing property management for 10 years. We've seen multiple houses, and after a 1 year stay, that's a pretty bad condition to see. So we just hope that you will see the evidence and you will make the decision based on what you see in the file and based on the documents we have.
I wonder
Just taking a final look at the pictures again to refresh my recollection.
Who's this guy that keeps walking behind the judge? Like it's his personal hallway. He's going to go back the other way. He's just getting like a coffee refill or something.
Great job.
No,
Switching
there's
out clerks
somebody.
here.
We just switched out the clerks because it's time. It's time.
Your Honor, and if I may add, it looks like most of the charges and most of the concerns that Mr. Garcia has are related to the painting or condition of the walls in the property. And I just found in our records that the painting was done 3 days. The full painting of the full interior painting was done just 3 days before they moved in a year ago. So it was a brand new painting inside. And if you look at the marks and if you look at the smears and everything that was left apparently by the animal, by the pet or animal in the house, maybe by the kids as well.
What did he have? Like a chupacabra or
excessive,
something?
extremely excessive. And that's why we had to do a lot of painting to cover and prepare, bring the house to the moving standard.
Wrong answer is only what kind of pet did he have?
Seen the pictures of the walls. I'm looking for pictures of the yard, which I'm trying to remember.
Let's get to the landscaping.
I wrote down a couple of the numbers for you just so you can look up a couple examples easier because I know there's a lot of photos. 2024-9-27-11-17-27 was a move-in photo from the backyard. And then I have a similar photo from move out as well. 2025 9-23 12 14 49. Can show that there was, some tall weeds growing and the sides of the yard were growing up on the fence and needed to be weed eated. The grass was very long and it was saturated from a leaking broken sprinkler that we didn't know about. We weren't told about it. So and then the bushes in the front by the porch, there's 2024 9-27 10-30 13 was one from move-in. And then 2025 9-23 14 15 26. It kind of shows how the bushes are kind of growing around the pillar and stuff. They weren't trimmed back and maintained.
You charged him for not trimming the bush.
Yeah,
I would not have paid $3,000, $4,000 security
I just
deposit.
to look at the breakdown of the.
If I'm also the landscaper for the place.
Can you remind me where that is?
Yeah, let's get the costs.
The cost?
For each charge.
Okay. So for all the invoices should be uploaded from both of us. Let me see. Like I said, I can't get off of that main page for some reason.
There's a blue arrow at the top if you're looking at one that looks like mine. Are they?
She's not.
I'm logged in looking at the exhibit list. When I try to go to the second page, it just goes back to the blank search page. I can't go beyond that for some reason.
Usually down at the bottom If you kind of scroll down the listing of a lot like the list of the files, I think down at the bottom there should be additional pages available.
Who's just
Yeah, and when I go to the next page, I just get the blank black page to search for it again. I'm not sure.
That's court.
Nothing's coming up. I don't know why it's doing that.
It's okay. I found it in. I think.
I know the carpet cleaning invoice and the cleaning invoice are on the first page because I can see those.
And were those provided within 30 days?
Yes, they were mailed with the settlement statement and the refund check.
Of $300, which he thought was a slap in the face because that's only a tenth, less than a tenth of what he paid. How much was rent?
Okay.
Has everyone said their final piece? Judge has the benefit of seeing the pictures. They
Ready
might
to
be
rule?
terrible.
Unless, oh, excuse me, Mr. Garcia, you had
Garcia's
something
like,
you wanted to say.
you're what?
Yes, ma'am. So like when it comes to the walls and the paint, when we spoke during the settlement meeting, they said that they were like had to do touch-ups, which touch-ups are painting a standard turnover, not tenant caused damage. When it comes to the enzyme treatment, that's preventative and not a repair. So that's also
Doesn't matter. It's preventative for the
not
next
tenant
person.
caused damage. And when it comes to Washington, the lease language cannot override the Washington law for or Fair Housing on Act ESA protections because the animal is a support animal. Yeah, I just wanted to bring those things up.
Do you provide proof for that?
And that there were scuffs in many rooms, but normal wear and tear can happen throughout the home. Doesn't just have to be in one specific spot. And a lot of the in the pictures, there's like you could tell that it's like kind of like wiped. It's from us trying to clean some of the scuffs.
That would be tenant caused damage.
Yeah, we tried our best when it came to like cleaning the home, and we spent several days cleaning it before turning over the keys, Your Honor.
Look at this pet addendum one more time.
Now there's a concern about the
So I was incorrect
support.
earlier. It does actually specifically say enzyme treatment in our lease agreement in the move out cleaning list. I'm sorry. And that.
Michelle, member for 30 months. You cannot
pointing
ask
to
for
what
proof
page?
that an animal is a service animal.
It is page 12.
I think depends on the situation. I get what you're saying. Yes, there's a presumption that's present there, but I think there's some wiggle room in that law where, like, a property owner would be allowed to ask specifically about what the service the animal provides is. I don't think it's like a documentation, but I think there's one follow-up question they're allowed. It depends on where. Somebody correct me if I'm wrong on that one, but I think there's one follow-up question that's allowed. Emotional support is different than service animal. Correct. Yeah, those are the two questions. Is this a service animal, and what service does it provide?
I have to disagree on the cleaning marks on the walls. They're dark black smears. When you wash a wall, the paint will fade. It doesn't get darker. And I just wanted to say that.
You did. Thank you. All right, the judge is still ready to rule. She's just trying to figure out the pet issue.
All right, let me go back to the right page that I had up here, and then we'll move forward. Thank you. Where did it go? I want the breakdown.
Laura says there are two different laws. The Fair Housing provides for provision of documentation for emotional support animals.
Yeah, I'm having some.
Interesting. Having some issues. Here's our rude walker behind her.
All set the way I wanted to, and then it changed.
Now reading over the shoulder.
Thank you for your patience.
No,
I
we've
am.
got all day, Judge. You're fine.
Here we go. As a pro tem, it can be working with the technology can be the hardest part. Okay. So when preparing for this case, I did look at the information provided by both parties. I looked at all of the photos. I also reviewed Washington law with regards to landlord-tenant. And particularly, I reviewed RCW 59-18-280, which states that no portion of any deposit may be withheld for wear resulting from ordinary use of the premises for a carpet cleaning, unless the landlord documents wear to the carpet that is beyond wear resulting from any ordinary use of the premises. For costs of repair and replacement of fixtures, equipment, appliances, and furnishings if their condition was not reasonably documented in the written checklist required under RCW 59-18-260. And so when we're thinking about this, I'm going to turn to the move out settlement statement with regards to what my ruling will be. I will.
She's going to split the baby. She'll allow for some of it.
While I do believe that there were a lot of scuffs on the wall, in my view, those were still within what I would constitute to be normal wear and tear. I do understand that it was perhaps greater than what you may have seen in the past, but as I did research into what constitutes normal wear and tear, it does not appear that this would go beyond what is normal wear and tear. It also did appear to me from the photos that the premises were reasonably cleaned, and there is.
Have a drink, Judge.
And that the types of cleaning that may have needed to have been done were within normal turnover. When we rent premises out, there is some work that needs to be done between tenants. I also note that under RCW 59, so I will not be ordering, I believe under general maintenance, $2,616.42, the turnover repairs and the cleaning, turnover cleaning, $822.75. That does not appear to be appropriate charges to me. With regards to the carpet cleaning, there is within, you were able to point me to where you were in the lease. It stated that enzyme cleaning would be required of the carpets, but I do note that in RCW 59-18-280, it states that that no portion of the deposit may be withheld for carpet cleaning unless the landlord documents wear to the carpet that is beyond wear resulting from ordinary use of the premises. And it appears to me that within your lease, this is a standard clause that you are including requiring carpet enzyme treatment when there are pets. And it appears to me from my legal research that tenants, although tenants are free to enter into leases that include certain lease terms, the tenants may not sign away their rights. And the specific language in RCW 59-18-280 states that charges for carpet cleaning may not be assessed unless it is wear to the carpet beyond wear resulting from ordinary use of the premises. I therefore find that carpet cleaning in the amount of $84.32 for the enzyme cleaning was not appropriate. With regards to the landscaping charges of $411.38, I do note that the lease does state that the landscaping is to be maintained by the tenant. And I have reviewed the photos for what needed to be done to the what needed to be done, and it appears that the tenant would need to pay for some of that. However, $411.38 seems excessive to me based on my experience with gardeners and with landscaping. But I will order that half of that be paid.
So he gets everything but
With
$206.
that, I will fine for the plaintiff in the amount of everything except for half of $411.38.
Wow. Bazinga.
Your Honor, are we allowed
appeal?
to ask questions?
No.
At this point, you may.
Well, we are a little bit confused with the ruling because we show excessive smears on the walls, which are definitely, in our view, in our understanding, which do not qualify as normal wear and tear. Because in this case, we're looking at many hours of work that had to be done to bring the property back to the condition, to the rentable condition. And if the tenant is not paying that, it looks like the owner will have to pay the bill.
That's the way the law's written.
The repair and maintenance bill. How can we justify that such excessive repair, such excessive time that was spent on the property can be considered as normal wear and tear? If you allow us to share the screen, to show the pictures specifically, I'm not sure if there was any technology issues.
Perhaps you were not here earlier for my speech in which I indicated that oftentimes when we go to a hearing, one of the parties is going to be disappointed. And I was not there. I had to go based on the evidence that was put forth before me, which was the photos. And the photos to me did not look that bad. I understand, and I hope you understand that I was not there. I did not do a walkthrough. I did not see it with my own eyes. And this was information that I did cover at the very beginning of this calendar when I stated that it is very likely that one of the parties will be disappointed because I was not there. I could not see what it was. And if anything, when I initially reviewed this file, it seemed to me that the types of charges that were being made were not reasonable. And after this hearing, I continue to feel that way. And that is my ruling and my judgment based on what I have seen, the testimony that I have heard. And that is my judgment. And I understand that you are disappointed. That is the nature of hearings. As opposed to reaching settlements, which is that one of the parties will be disappointed. In this instance, with regards to, I did do my best. The question of what is normal wear and tear is something that has interested me for quite some time. But I think that based on the photos that I have seen, that this is the just and legally correct result.
I rebuilt my whole unit before the tenants moved in.
Mr. Garcia, can you remind me of what the total amount was that needed to be returned?
$4,000
So for
minus.
landscaping, they charged me $411.38, which you said would be a half. The carpet cleaning was $84.32.
So real quick, so I'm looking at the settlement statement. It looks like the total deductions were $3,934.87.
Yes.
And then I stated that part of that landscaping was appropriate.
Subtract 205.
So I'm going to go 3934.87 minus 205.
11.
69.
69. Hey. There.
So I'm going to order a refund.
You got your checkbook out?
$3,729.18.
There you go. So ordered. Wow. It does make me a little bit nervous
That is my ruling.
A landlord, as a property owner, renting out a unit. But this is why we just don't rent
Your
out
Honor,
to anybody.
the check of the $377, I just throw that away, like rip it up and just
or return it.
What I would do is I would write void on it and mail it back to the company.
Yes, Your Honor.
Oh, wait, let me look at this math here. Because you were refunded, the deductions were $3,934.87. And then they refunded you the $377, which you are allowed to keep because my ruling was that they overcharged you. So I take that back. You can cash that check and they owe you another check.
Yes,
in the amount of $3,729.18.
Wow. This dude, Eugene Klein.
Okay. With that, you are free to go. You'll be able to get a copy of this judgment by Monday.
Thank you, Your Honor.
And that is that. Yeah, they had already spent it. I think they'd spent it on repainting the house or touch-ups or whatever.
2025.
Send them the voided check.
Let me know when we're off the record.
We're off the record. Because we've got things to say off the record. All right, as they go off the record, let's see if we have anything else in Thurston that needs our attention right off the bat. 2 is not on, 3 is not on, 4 is not on. Nothing else is live in Thurston right now. Let's see, who's this? 13th Judicial in Kansas. That was Judge Ricky? Hang on. Well, he's not live anymore.
This is the Butler County, Kansas first appearance docket of January 2, 2026.
January the
I'm
2nd.
David A. Ricky, District Judge. The first case that the court will take up involves a Carly DeVere. Is that who I have at the jail's
Judge
Zoom
Ricky,
location?
coming to you live from the bathroom.
This is State of
echo.
Kansas versus Carly Brienne DeVere. It's case number 2025 CR 90. Defendant appearing at the jail Zoom location. Darren Devaney appears as Butler County attorney. Ms. DeVere, I have a warrant to show cause alleging probation violation, failure to obey the law, failure to report to your court services officer, failure to pay on your case, and failure to report law enforcement contact immediately over the next working day, as alleged by Ms. Donovan from court services. Further hearing will need to be set on these allegations with this court. This court's next docket for that purpose would be January 30, 2026, 2:30 p.m. Ms. DeVere, if you are able to make your bond in this case, and it's currently set at $10,000 cash or professional surety required, you will need to appear at the Butler County Judicial Center in El Dorado, Kansas, and no other location on that day.
Oh, Joyce.
On the 30th, Your Honor?
Correct, January 30th at 2:30.
And I get out that day?
Just for court.
That's yet to be determined.
Oh, sorry. Your Honor, I have major court on Monday in Wichita, Kansas. I'm severely homeless. I've been calling my probation officer every time I can. She told me to just let her know what's going on, and I just got out of outpatient treatment not even 3 days ago.
All right, well, we're not really going to get into the substance of the allegations against you
Okay.
this time. Ms.
Okay.
DeVere, I'm sure that you have some explanation that you'd like to give.
I think major court is
But,
felony
the
court.
reality is the court's insecure about any lower bond than what's currently set. I want to leave it where it's currently established at $10,000 cash or a professional surety required. If somehow you do make that bond, you must immediately report to your court services officer. And like I say, appear at the Judicial Center for your January 30th court in no other location. Obviously, if you're still incarcerated, you'll participate from where you currently are.
Okay.
Now, I trust you don't have the resources to hire a lawyer then?
No, Your Honor, I don't.
All right.
Do you know how I can get a hold of my
James Watts
outpatient?
will be appointed as your lawyer.
Okay, James Watts. Okay. And I can write him and he can tell Wichita Outpatient Services that I'm here incarcerated?
He very well may be able to do that if he's able to make contact with you.
Okay.
So James Watts is appointed. We've got a January 30th at 2:30 court date.
And that's my second appearance or my sentencing date, Your Honor?
Well, your sentence will be reviewed on that date, Ms. DeVere.
Okay.
If there's nothing further, Mr. Devaney?
she's
are.
done.
We'll
Got
move on to
everything I
another
need.
case.
Man.
Can I write some James Watts on here?
Man.
Thank you.
She go.
Ryan? Rick's still down here?
Mr. Devaney seems to be sitting in Mr. Aguirre's chair.
After this guy, yes.
All right, another individual is coming into the detention facility Zoom location. Who do I have?
Ryan Thole.
This is State of Kansas versus Ryan Lee Thole, case number 2026 CR1. Darren Devaney appears on behalf of the state. Mr. Thole appears at the jail Zoom location. The court will inform the defendant that count 1 of a charging document alleges non-residential burglary, a level 7 non-person felony. Count 2, theft, a level 9 non-person felony. Count 3, criminal damage to property, class B non-person misdemeanor. Since felonies are involved, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before you are assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be February 9, 2026, 2:30 p.m. You must plan to fully participate in Judge Satterfield's docket at that time, February 9, 2:30 p.m. Mr. Thole, do you have the financial resources to hire your own lawyer?
Probably not.
Okay, were you working prior to your arrest?
Yeah, I was. I just started.
Yeah,
Okay, what kind
thieving
of
is
job
not
was
the
that?
work.
Automotive repair.
Oh.
Mhm.
You can't say I was picking up
Obviously
loose
has some
copper
skills that you
scraps.
could use. But this is a serious matter. The court's going to resolve doubts at this point in going ahead and appointing the lawyer to represent your interests. James Watts will be appointed. You can replace him with retained counsel if you want to, Mr. Thole. What bond do you recommend here, Mr. Devaney?
Your Honor, I'd request a $5,000 cash or surety bond. In this case, the weight of the evidence was significant. The defendant did admit that he had went into the storage unit. He was seen by witnesses. There's also photos of his vehicle. It does have some criminal history, including felony thefts going back to 2020. Did have a failure to appear in 2020 as well on that. And I also know he was arrested by Wichita Police Department on another case. Butler County Sheriff's Office went to interview him while he was in custody in Wichita at that matter. But I think $5,000 cash surety, given the severity level of the offense, would be appropriate.
The court concurs. The court will set bond in this case at $5,000. Cash or professional surety required. And it must appear and participate in all scheduled court appearances on time. We've got a court date set before Judge Satterfield, February 9, 2:30 p.m., and James Watts is appointed. Anything else we need to address here, Mr. Devaney?
No, Your Honor.
All right, Mr. Thole?
Understood.
Very well. The Thole matter is currently in recess at this time. We'll move on.
Okay, we're actually going to move to a different 13th because
time.
Hang on. Stop.
We've got a court date set before Judge Satterfield.
Because Mr. Aguirre's live. Where's he? All right, there he is.
Violations, we'll take that matter up, and I'm the only way I can be sure right now that you're going to be is if you're in custody. So January 16th at 1:30.
Same district,
And
different
that
judge.
concludes Mr. Carter's case for today. And that takes us to State of Kansas versus Mark Fry.
Your Honor,
Yes.
there's someone in the waiting room with Premier monitoring, but I did not see a subpoena in the case for this hearing.
Okay, who is this for? Mr. Fry's case?
That is for Fry's case, Judge, yes.
Okay. Well, if you could put them in from the waiting room, then please, Jen.
Well, never mind it. They just left. Okay. If they come back, I will.
All right. This is State of Kansas.
Judge, I apologize.
Yes.
I need a quick, I got something going on. I got to take care of it.
Okay. I'll a brief recess for Mr. Patterson. I'll remain available.
Your Honor, if I may go off mic and off camera in the interim.
Yes, just that'll be fine. We're in recess.
Mr. Gary, yes, you can resume charging. We'll charge for a minute. We'll be back. We'll be back briefly. It's just him now. It's just us and the defendant. Mr. Aguirre is an amazing prosecutor. His knowledge of the law is fantastic. His ability to access information is limited only by the slowness of the network, which he's like mentally attached to. I'm not sure what the tear tattoo means. I know in some gang cultures it symbolizes death or loss or possibly murder. But I'm not sure specifically in this case what it is. Regier looks like the Don Adams in Get Smart in the 60s. Mr. Patterson just took care of whatever it was. Comes back with a smile on his face. Makes us a little curious.
Mr. Patterson?
Sorry, Judge, for the interruption. Ready to proceed.
All right. Mr. Regier?
He has to unplug from the charging port. There he is.
Apologies, Your Honor.
That's fine. State of Kansas versus Mark Fry, case number 25 TR 873. Would counsel state their appearances, please?
Jerry Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Mark Fry. Mr. Fry does appear via Zoom audiovisual from the Butler County Detention Facility. Judge, this is a case where it is a warrant to show cause. I can tell the court Mr. Fry also has another probation violation case with Judge Hart. He also has a new misdemeanor case with Judge Webster. My request to the court here today is to set this over to the same date as Judge Hart's, which is February 6th at 2:30. The only reason I'm asking that, Judge, is I would like to get all these together and do a global plea bargain and take care of them all at once rather than piecemeal them through. Further, I would need a continuance anyway, Your Honor. At the last court hearing, we did have the electronic monitoring folks on here. They were subpoenaed in. They were one of the main issues has to do with whether there's violations or not. And at the last hearing, I asked the court for them to provide me their records. The court did order that, and I haven't received anything. I don't know if the state has, but I don't have anything. So I'm not prepared for the hearing anyway, Judge. So I would ask the court to consider this continuance to that February 6th, 2:30 docket, probation violation docket, and ask that this be with Judge Hart. And I'm going to plead to get the other case with Judge Hart so I can take care of them all at one time and save a lot of time for everybody, hopefully.
Mr. Regier, I'm going to be there.
No objection to resetting this matter. What I would tell the court is the state is aware of two other open Butler County cases involving this same defendant, 24 CR 366, State's information is that is currently set before Judge Hart at 2:30 on February 6th for a request for revocation. And the other case, 25 TR 2713, that appears to be currently scheduled before Judge Webster 3 days following on February 9th at 9 a.m.
Same information that we heard from Mr. Patterson, but with just a little more detail on the date and time. But wrapping this all into one big case is...
Well, I recall the witness that that Mr. Patterson referred to, and she assured us that their office would get that to you, if I'm thinking of the right individual, because she patiently waited to an end of a docket until that particular case was called. But sometimes these electronic transfers, for one reason or another, don't go through. I don't know what's happened there. I will grant a continuance to the defense.
And Judge, I have put in an email to Judge Hart's AA just to verify if Your Honor does allow it, to make sure that they are all right with it also. And I can communicate with your office also to make sure that if they say Judge Hart agrees, then I'll let you know.
Well, it won't hurt my feelings. However, I've been instructed in regards to not do that without, I know there's been some concerns in the past. I'm not saying this is what happened in here for forum shopping. And the problem with doing a global plea is if somebody picks up new charges, that kind of just keeps on going on and on, potentially. And there's an allegation of new charges. So,
and Judge, there are certain judges I know that have a particular, they don't want to take these other cases, and some judges don't have any problem with it generally. Judge Hart's one of those that does not generally have any issues with it.
Well, and like I say, it won't offend me at all, but if he indicates he wants to take it, and of course, Chief Judge Ricky is the one that makes the case assignments. This matter was moved to me because it looks like, well, he was scheduled before me when he on December 19th, and he failed to appear.
Yes.
So
he knows he'll be staying on a no bond hold, Judge. He's not expecting to be out of jail.
All right. Well, I'll set this for February the 20th then, because the 6th date would be my next date available, other than January 16th, if you want to take it up then. But it doesn't sound like these other matters are going to be resolved before then. So I can either set it January 16th, February 6th at 1:30. Won't help you much with if Judge Hart's isn't until 2:30. But I'll continue it to February 20th, the defense request.
And Judge, if we continue at February 20, but if Judge Hart would agree to take it up, does the court have any objection to that if Judge Hart agrees to do that?
Not if there's, no. I like I said, it won't offend me at all. But,
thank you.
So, but I also don't want to.
He doesn't get paid by the case, so.
It's not my job to make the court assignments. That's Chief Judge Ricky. So, I no problem with hearing Mr. Fry's case either. So I'll set it down for now for February 20th at 1:30. In the event that it's been resolved through other cases and as well as this one, then it'll just be removed from the docket.
Thank you, Judge.
And in the meantime, he'll remain in jail on no bond hold.
He's going nowhere.
So that concludes Mr. Fry for today, I believe.
Thank you.
That leaves
Your Honor?
us. Yes,
That is the only thing I had with you. May I be excused?
yes.
Thank you.
All right. State of Kansas versus Cheyenne Pamp, 23 CR 413.
Judge, I would inquire of court security.
Yes.
And Judge, this is a case where I was going to visit her in jail, but she did already get out of jail, so I have not spoke to her yet. I would need to talk to her, but if the court would allow, I would ask to talk to breakout room with Mr. Regier and Miss Ashenfelter first.
Okay, any objection, Mr. Regier?
It's ginger spice.
All right, I'll call a recess until, how much time do you anticipate, Mr. Patterson?
Probably 5 minutes with Mr. Regier and then at least 5 minutes with my client.
Okay, why don't we, I'll plan on reconvene at 2:45. I have it as 2:37 now.
Got 3:38.
Well, no, you need a little more time then, won't you? Let's make it 2:50, but we'll be in recess until 2:50. So if other people that are on the docket needs to step away for a personal break, then they'll be able to do so. So we'll reconvene at 2:50.
Thank you, Judge. And Jen, could you put Mr. Regier and Miss Ashenfelter? Yeah, thank you.
And the defendant? She's just sitting here. Uh-oh. Okay. I was nervous there for a minute, just for a minute. She's using the Zoom. It's like her personal mirror. It's grooming time. Yes, she can see herself. I think that's all she can see. I see a little snarky, the shrug of the shoulders. I can't hear what she's saying, obviously, but the shrug of the shoulders and the attitude seems, yeah. This might not go well for her. Beautiful hair color, yeah. Is it a Scarface shirt she's wearing? She looks to be inconvenienced. Joyce, I think that's a good description. She's like, why is it taking so long? I've got places to be. Yet she's also trying to flirt with the bailiff, I think, just a little bit. Hang on, I'm going to text Phil real quick. It says as a parent, let's see. Adidas, wicked sponsor. Apparently. We're going to go with the ponytail. Nope, we're going to go with the bun. Braid, maybe? Nope. Going to go with the curled up. And held in place. Oh, across the eye, maybe. Just rat it up a little bit, fluff it up. It's all over the shoulder. Split it in the middle. Ponytails. Oh, no. How does it look? We're back.
Jim, I have a breakout room with court security. Do you want the court security 2 or 3?
You can just do it here, Darren, at court security 2.
That'll work. Thank you.
You can't just do it here. You need a breakout. That would be attorney-client. Okay. And she's going to be gone here just a second. She gone. Oh, man. Well, she's redhead, so she's void of any soul. I say that as the parent of a 5-year-old redhead son. It's a little slow day. We're waiting to see how this one resolves. It looks like Attorney Patterson possibly was able to secure a plea deal in this. So we'll see if the client is amicable to the situation or to the conditions of the plea. If so, this might be very quick. But beautiful hair, beautiful hair. Redheads are like 2% of the population. Ivan is being harsh. He says that as a parent with a redhead. I don't know if she strikes me as the amicable. I think Mr. Patterson has to do a little bit of talking here to get everything to work together. I think the judge is going to be back in a few minutes. We've got maybe 6 minutes or so. Redheads have a high pain tolerance, says Northwest. Are their pain receptors just not as efficient? What is the reasoning behind that? Is it because they get teased more? Yes, we do, says Karen. High pain tolerance. Hey, little Miss Hori, how are you doing? We're watching a blurry screen right now. She came in to watch court. She's like, what are you doing? We're watching a blurry screen. It's true, I'm a redhead, and I have a high pain tolerance. They'll have to go to the little lawyer's room. Okay, let's do a quick poll, shall we? Now that we're talking about redhead, I wonder if redheads are 2% of the population. The question is, are you a redhead? And the yes, natural. Yes, hair dye. And no, I have a soul. No, just kidding. It's just no. Okay, we'll start the poll there. So vote. Let's see what percentage of redheads we have in chat. See if we have 2% represented here. Make yourselves known if you are a redhead. If you are, you have to vote. You've got to vote. So if you're not, I guess vote as well. But crazy facts about redheads. Is it true that there's a correlation between having red hair and colorblindness? Did somebody told me that once, and I'm like, seriously? Your hair and your eyes, is that connected? I'm not sure if I believe that, so let me know. No connection, says Karen. None at all. What about former reddish? I guess if it was your natural color, because I'm going gray now, so that's going to be my color. But if my color before was red, I would say I was a redhead. Redheads are too ornery to show pain. Coming from a 4'11" redhead grandma, scariest little woman I ever met. I'm a blonde with very low pain tolerance. Does natural auburn count as a red adjacent? Is that like strawberry blonde? What's strawberry blonde? Ivan says RA is truly just trying to get a ginger registry, and I'm in agreement for maintaining safety. Yes, this is going straight to the no-fly list and the feds. Auburn's on the red spectrum. Sunburn is strawberry blonde for brown. I think we're back. Darren Patterson's back. We'll get the defendant back. Jim McIntyre's watching. Ladybug's mom gifted a membership. Thank you, Ladybug's mom. That went to Freebird 11. All right. Oh, the bailiff has taken a seat next to the defendant. In a rare move.
Yeah.
I guess they're friends now.
Yeah, that one.
I guess the flirting worked. So. Glasses on. She does not seem as happy. I see a little bit of a pursed lips, little frown. Young Lindsay Lohan. I see that. I can see that. Redheads don't absorb medications well. I think we covered this once before. I don't think she's happy with the... oh, screen went dark. What just happened? Wiggle the mouse. Oh, there it is. Wakes up again. Yeah, there's a frown there. This is not a happy camper. I think she either had to plead guilty to something she didn't want to, or she's not excited about what the possible penalty is going to be. But, yeah, shake of the head, sigh. Now I need to know what it is. What's the, it's almost 3:50. Judge, if you can come back any second now, that'd be great. You know Mr. Regier is not going to go easy on her. The red hair, the tricks, the androids have no feelings. They just, the law is the law. Okay, we're going to end the poll here. If you haven't voted, you pretty much lost your chance. So, ending the poll. Look at this. Holy cow. We have, if redheads make up 2% of the population, we have 8% of you saying that you are natural redhead. Another 10% red hair by elective, and 82% with a no. Wow. This is concerning. Now we know why we like murder.
Yes, Your Honor.
This is State of Kansas versus Cheyenne Pamp, case number 23 CR 413. Would counsel state their appearances, please?
Chair Regier, on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Cheyenne Pamp. Ms. Pamp does appear from Courthouse Security 2 video station. Judge, this is a warrant to show cause. I can tell the court that Ms. Pamp is going to waive evidentiary hearing, that she will stipulate to the violation, specifically that on November 7, 2025, she failed to report as directed, that a letter was sent out directing her to report November 12, and she missed that date also.
Revoke. Bailiff's going to have to
Are there
put
any
the red
other
handcuffs on the
agreements
redhead.
between the parties?
Judge, at the time of disposition, there is an agreement to recommend to the court a 48-hour sanction and then reinstate with all prior conditions. I'll have additional information for the court later.
The weekend in jail?
Mr. Regier, is that your understanding of the agreement?
It is, Your Honor. While the state does recognize that under the case law, the defendant would be entitled to credit for time served if the court does make such orders, the state is not recommending that the defendant receive credit for any prior jail time towards the 2-day sanction.
All right. Ms. Pamp, have you heard what the attorneys have told me?
I have, and I did want to add, like, okay,
Before
my
you
bad.
go on,
My bad.
are you agreeing to what they've told me?
Yeah, yes, sir.
All right, I'll give you an opportunity to explain yourself a little bit if you want to later, but right now I need to be sure. You understand that you're entitled to a hearing where the state would call witnesses and they would have a burden of proof of preponderance of the evidence to show that you violated the terms of your probation.
Yes.
And is it correct that you wish to waive your right to that hearing?
That's correct.
And you're admitting your violation?
Yes, sir.
Have you had sufficient time to discuss this with Mr. Patterson and make that decision to waive this hearing?
Yes.
Has anybody forced or coerced you in some fashion to enter that decision?
No.
Are you under the influence of any medications or intoxicants at this time?
No.
Very well. I do find that the that the defendant is waiving her right to an evidentiary hearing on whether she violated the terms of her probation. And so I will hear additional, I do find that she's violated, that she's had the advice of good counsel, and I will consider arguments at this time in support. Well, Ms. Pamp, you understand that while there's recommendations that both parties have agreed to make, I'm not bound to those. You could be ordered to serve your original sentence.
Yes, sir.
All right. Does that change anything about what we've talked about?
No.
Very well. I find she's knowingly and voluntarily waived her right to that hearing. I'll hear from the parties at this time if they have additional matters to state. I'll start with the state.
Nothing further from the state on the issue of disposition, Your Honor.
Mr. Patterson.
Judge, we would ask the court to adopt the recommendations that are presented. I can tell the court, and the court may have seen this already in the journal entry of sentencing in this case. It was ordered that it run concurrent with 24 CR 537, which is a felony case that she is currently on community corrections. That she did have a warrant to show cause in front of Judge Rickey on December 30, 2025, concerning the same violation of not reporting November 7, but then also in that felony case, there were additional alleged violations of not completing mental health counseling, Senate Bill 123 treatment. So that was a separate matter that happened December 30. She waived hearing, stipulated the violations at that time, and Judge Rickey ordered a 48-hour sanction, then back on to probation. She's completed that 48-hour sanction and appears today in court. Judge, we would just ask the court, given that this is the violation and that she does have so much to complete on Senate Bill 123 to better herself, we'd ask the court to allow 48-hour sanction in this case and then back on probation to complete all terms.
All right, counsel, is this, in this case, is running concurrent with 24 CR 537? Is that your understanding as well?
That is in the journal entry, yes, Judge.
That does appear to reflect on page 1 of the journal entry, Your Honor.
So she gets 48 hours in jail.
And counsel, what was that charge? If you know what the
It's going to be a possession.
Conviction was for?
In the felony case, Your Honor?
Yes.
Your Honor, pursuant to the felony sentencing journal entry filed in 24 CR 537 in October of this year, page 1 does appear to refer a conviction of possession of methamphetamine, a level 5 non-person felony.
Man, so young to be messed up in meth. That'll destroy your life.
Counsel, anything further?
No, Your Honor.
All right, Ms. Pamp, is there anything that you'd like to state or make me aware of before I make my decision?
I did just want to say that like I know that I do know that I do take accountability of the fact that I did mess up, but I just wanted to like let you know that I'm still trying really hard, you know. I'm still trying to jump through all the hoops. I'm not you know what I mean? I've never tried this hard towards something as I have like this past two times that I've been doing the corrections like. And so I just wanted, I don't know, I just wanted to let you know that like I'm still putting in as much effort as I possibly can. And that but I do take accountability for the fact that I messed up last time. I don't know, I just wanted to let you know that like I'm still trying. I'm still doing everything in my power to make sure that like I get this done and I do this and I do what I'm supposed to do, you know.
Well, I'm going to hazard a guess that one of the violations on the felony case was you hadn't been working your drug treatment program. Is that right?
Yeah, I had failed the report with the moment I was or whenever I was supposed to start group, but I have a thing set up with South Central. I was supposed to do that. I had an appointment the day that I got in or went in for my 2-day sanction last time I had it set up that day. I had to reschedule it because of the fact that I went in that day. And I have it set up again, but I'm just trying to figure out, you know what I mean? That is set up, that's in motion. I just have to be able to get to the appointment to go without, you know what I mean, being in jail to do it, you know?
So she doesn't want to be in jail, so she can go to her appointment.
Your community correction officer is here, is that correct?
Yes.
Okay.
Anything from you?
Ms. Ashenfelter, since the defendant was released on Judge Ricky's, on the revocation on her felony case, how has she been reporting as directed? Has she signed up for what she's supposed to do and so forth in that case?
Your Honor, she was just released recently from that jail sanction, so I have not seen her since then. We do have an appointment scheduled.
When's your appointment scheduled?
It's on the 7th.
So January 7th?
Yes.
So if she gets a 48-hour hold, she can be out in time for that. No,
Did she ever get an alcohol and drug evaluation or treatment with a recommendation for the treatment on the meth?
Yes, she is a Senate bill case, so she did the evaluation. She just never started anywhere.
Ms. Pamp, is there anything else that you want me to consider before I announce my decision?
No, that'll be it. That'll be it.
Well, Ms. Pamp, part of my concern here is if this is the best that you can do,
we have a problem.
If that's accurate, then if your past performance is the best that you can do, we might as well just have you serve your time.
I'm not going off my past performance. I'm saying right now, like since you know what I mean, I understand that I messed up and I got bonded out, and ever since I got bonded out, and I've been putting my all into this, and I've been like.
Well, you're talking about since what, December the 30th?
Well, even before then, but I did have like a death. My best friend, he passed away, and then it kind of, I kind of got off track a little bit, but I turned myself in, and I've been doing everything in the steps that I need to do to get myself back on track and continue to pursue to get the things done that I need done. And
you can see it in their eyes. They've worked with her. They know she's not there yet. She needs help, but I'm not sure if she's ready.
I'm going to take this matter under advisement and reset it for February 6th at 1:30. Well, Mr. Patterson, are you available then? You mentioned another case at 2:30 before Judge Hart. So
That's been a pretty common issue, and I'm just taking care of your docket, Judge, and then going into the 2:30 docket when available. So no, it's not a conflict.
Judges are pretty good working with each other's
okay,
schedule
well,
like that.
I'll set it over to February the 6th. I'm sorry if I'm keeping messing with his docket. I don't mean to do that. I'm going to continue it to then. I'm going to order additional that Ms. Pamp report to Community Corrections today. Can Community Corrections take a UA of her?
Yes, Your Honor, we can do that.
All right. And I'm going to want a report in regards to how that UA has turned out and if she's been reporting Ms. Pamp. I haven't made my decision I found that you're in violation of your probation. I haven't made my decision on whether or not to revoke you and have you serve the 6 months. On felony cases, oddly enough, there's more restrictions on the judge on how many times they have to kind of, give a person more time to work a program. On misdemeanors, oddly enough, you're not entitled to even probation on the first go round, and that was done. And I'm not asking for you to comment, but I tell you, you haven't shown very well in regards to it, because it looks to me like the very first time you were to appear to your probation officer, you blew it off and didn't show up then. So if you've got more failure to reports and you're not doing what you're supposed to be doing on this probation, that I'm going to find that out February 6th. I'm going to find out if you tested positive or negative today. You should be negative based upon what you're telling me.
Yes, sir.
She should be, but that's good.
So I'm going to give you a little bit of time for you to follow through and show that you mean what you're telling me here today, because frankly, I'm a little bit concerned that you don't follow through with what you're ordered to do, based upon what I've seen in this case and what I'm hearing from these other matters. So February 6th at 1:30. And I would ask that the results of the UA be sent to defense counsel as well as the prosecutor's office. In the event that it's positive, unless the defendant, we'll just deal with that at the time. But probably it'd be best to get it confirmed in the event that it's positive.
Yeah, that get it confirmed. That's because they all suspect.
I hope that's not going to be the situation, but I'm ordering that once we're done here today, you need to go see Ms. Ashenfelter. Am I pronouncing that correctly?
Yes, Judge, that's right.
I don't normally deal with community corrections, so I'm not. I don't know that you've testified before me before, so you need to go meet with her. They're going to take a UA and we'll go from there. But
And Your Honor,
anything further? Yes.
as a point of clarification, does the court wish my office to issue another subpoena for Ms. Ashenfelter for the next setting?
Ms. Ashenfelter, what's your office require in that regard?
They have to subpoena her?
I have it on my calendar, Your Honor. I'll be there.
Okay, well,
They have to subpoena her.
sometimes I've seen some offices where they want that in the file, so just in case, but we'll go to February 6th and see how things are going. All right. Anything further today on this matter?
No, Your Honor.
Okay, Ms. Pamp, you know where you're supposed to go immediately?
Yes, to Christie's.
And very well, that's correct. So this matter is adjourned and the parties are free to go. I think we just had the one other case, don't we, Mr. Wadowski?
Yes, Your Honor. He's in custody.
Mike Wadowski.
And before we get on the record on that, I did read your proposed journal entry for today. Mr. Regier, are you going to have a problem with that?
3 points of clarification, but perhaps that would be better taken up
on the record.
On the record upon the court successfully entering its orders.
All right.
Deputy?
I have a Jerry Davis here as well. Is she not needed today?
That case was dismissed. I thought she was being released.
Okay, I'll get with booking and see what they have for her.
Jerry's like, that's the best news I've heard all day.
Yeah, I've seen the order of dismissal also, Judge. It's filed today.
Okay, well, I saw your message, so I was assuming that had already been processed and the jail had been told. So, okay, yeah, that'd be fine. Yeah, Ms. Davis is no longer on the docket. So, yeah, I think she's supposed to be released.
Okay.
All right.
All right, I'll have Mr. Podolsky come in.
So what's this cleaner, Ivan? Is there actually something? I mean, I'm asking just out of pure curiosity, not for a friend or anything else.
Not guilty.
And it works? Who says not guilty?
All right, we're on the record now. This is State of Kansas versus Stanley Wadowski, case number 25 CR 545. Would counsel state their appearances, please?
Pierre Biggie on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Stanley Wadowski. Mr. Wadowski does appear from the Butler County Detention Facility video station. Judge, this is a...
Before you go on, Mr. Wadowski, can you kind of sit back, please, so we can see your face rather than the top of your head? Thank you. Mr. Patterson, please proceed.
Thank you, Judge. Judge, this is a case where at first appearance, a week ago or two, something I can't remember, but he was in front of Judge Satterfield. Judge Satterfield had concerns about his mental health, had requested the jail notify me to go out and see him. I have met with him. I share that concern at this point that I cannot determine whether he does understand fully the issues that are before the court or the process that we have here. Based upon that, Your Honor, I do believe that a competency evaluation would be appropriate. I make that oral motion here today and ask the court to make such an order. Thank you.
Mr. Regier?
Your Honor, I was not present at the initial first appearance hearing. I have no knowledge as to any indications Judge Satterfield may or may not have made on the record. Naturally, if the court does make such an order, the state will wish to be heard on the exact terms of the order.
Well, I reviewed earlier the docket notes from that first appearance that Judge Satterfield heard, and it's consistent with what Mr. Patterson has advised us. So I will order an evaluation. I reviewed the proposed order for competency evaluation. I've got no problem with it other than I don't know what their scheduling is, if they would be able to complete that by January 16th at 1:30.
Judge, they would, and I can see my order has some errors in it on dates. I'll correct those dates and show today as the date of the hearing. And I would ask the court to set it for January 16. We can get it done easily by that time and have it back before Your Honor.
I'll set it for January 16th at 1:30 unless Jen thinks we're too crowded on that day.
That's a good date still.
Okay. So, Mr. Wadowski, there's going to be somebody coming from mental health to talk with you. And I'd encourage you to contact or be in contact with Mr. Patterson, and we'll take up your case again on January 16th at 1:30.
Thank you, sir.
And Your Honor, the state does have two concerns regarding the proposed order that the state wishes to address on the record.
Please, go ahead.
Your Honor, in addition to the issue of dates referred to by counsel for the defense, the state is requesting that the journal entry reflect that it is the court that is making these orders. Additionally, the state would request that the order reflect that the proceedings in this matter are being suspended pursuant to KSA 223302 subsection A.
Well, as a statutory matter, I believe that, that's required. So yes, basically it stays the speedy trial issues until this is dealt with. So
I do have in there that is pursuant to KSA 223302.
I'll let counsel discuss the journal entry. Journal entries often can have several things that, counsel might want to word better or so forth, or the other party thinks can be worded better. It looks to me like this one will work fine, but if there's some corrections to be made, I'll let counsel work on that.
Thank you, Judge.
Thank you, Judge.
Anything further on this matter?
No, Your Honor.
And Jen, does that complete the docket?
Completes the docket.
That is all I show, Your Honor.
Okay, does court security have anybody else there that's appearing for today?
No, we don't.
Thank you much, everyone. And Mr. Patterson, hope you get feeling better. So
I do too, Judge. Thank you. Have a good day.
You too. We're adjourned.
Bye-bye. Mr. Aguirre, this is still live. Mr. Aguirre's just holding still. All right. Hopefully, not to make any light of it, hopefully, you know how I feel about mental health in jails. It is the worst possible environment for somebody to be in that has mental health issues. There are some jails that have, I guess you'd say, good mental health treatment programs, but it's making good of a bad situation. It's terrible. It's terrible, terrible, terrible. We need to do better as a country to dealing with mental health, both destigmatizing it so that people don't try to hide it as much, and maybe talk about it a little more openly so that people understand what it is when it happens, as well as treating it. So I think Monday we get a new trial. I think so. I'm thinking. Let's see.
Green Maldonado is 26 CR, 33C.
This is Fulton
He's
County.
got 9 misdemeanor charges, starting with driving on the wrong side of the road, center lane.
You hear me?
Yeah.
Yeah,
Is
my
that
man.
Mr. Maldonado?
No, it's Mr.
No.
Mr. Williams said he don't want to do pre-trial, so.
Oh, he doesn't? Okay, then I'll give him $1,000 surety bond, and his next court date will be January 15th.
Driving on the wrong side of the road.
Okay, so on position 3, it'll be $1,000 surety bond. Next court date is January 15th.
That's 13, right? Number 13.
Right.
1-3, yeah.
Sorry, who do we have in court 2?
This is Mr. Dupree, the second add-on.
Okay, I'll be with Mr. Dupree shortly. Mr. Maldonado, as I was saying, his accusation is 26 CR 33C, and the charges are driving on the wrong side of the road, center lane violation, failure to obey control devices, failure to obey safety zone, driving within a gore, speeding. I believe it was a super speeder violation.
There was a gore
failure
violation.
to use the signal where required, reckless driving,
Was this a
and driving
police
while
chase?
license suspended or revoked. This is
He did
unfortunately
all the
not Mr. Maldonado's only traffic case that's open.
No, Your Honor, I don't know if you remember, this is his second time for the same issue. You handled him originally on December 20th.
No, I don't remember. Sorry, Ms. Correa.
So this was something that I'm happy to discuss at the end, but it seems like the only reason why I can speak about it is because I happened to be the public defender that day as well. But he was arrested on the felony case that you see. But what it seems to have happened is that different sets of officers all took out their own warrants. So these are all warrants stemming from the same set of facts, circumstances, nucleus
Does
of
he
operative
does he have
facts.
a bond already on these charges?
Yes.
It's probably more than 1,000.
Let me pull him up. If he does,
Is this the one where I issued a bond order, but we didn't have an accusation number at that time?
I think so.
possibly, but it's since been
Fulton County's messed up.
the
We're in
chart
Georgia,
like
by the way.
they've all been handled under 25 PI 010280.
All right. Miss Binford, why are we accusing this case that was addressed in a felony case, or is felony court sent it back to us?
It was not in my understanding that it was at felony court. I got it from our state court. I didn't see any transfer, any request to transfer that up on my end.
How many times are you going to prosecute the guy for the same
All right.
offense?
Let's go with the same one then. Position number 9, he already has 1,000. Well, I'm not sure how to do this, but so I'll leave it till the end. So let's go to our second
He
add-on,
just wanted to
which
leave,
I
and
have
now
not
he has to wait till the end.
seen, but let's see, what do we have?
Yeah, stay out of Fulton County.
This Dupree, right?
I don't know. I'm just trying to get to the main screen. There we go.
Okay.
Okay.
Talking about stuff that is not relevant.
It's also Fulton County.
Ronnie Dupree, case number 26CR39G. Mr. Dupree is charged with 1 count of simple battery family violence from December 31st, 2025. His case number is
New Year's Eve.
25.
New Year's Eve family fight.
Gosh. CR, I've already said 39G. Okay. Mr. Dupree, you've been advised of your right to remain silent, and your attorney is going to be Ms. Correa. And
Okay.
I do apologize. This calendar just got sprung on us. So let me see. He's been in custody now.
Since the 31st.
For 2 days. Charge booked in on January 1st of 2026.
Happy New Year.
And we do have a warrant. I think it's a warrant. I don't know if it's a private warrant. Yeah, we do have a warrant.
Private warrant. Is this Seth Brown
Under
from the YSL
warrant
trail?
number
What?
EW 0513478. All right. Mr. Howard, do you happen to have his priors, if any?
Yeah. 21.
Okay. 21 cycles. Okay.
I got a 2024. Henry County. Hold on. Yeah, battery DV, ag assault, obstruction. That's open. I got a 2022 arrest. Hold on. Out of the cab. Ag assault, possession of a firearm by a convicted felon.
And when was this?
He was arrested in 2022, but
Oh,
it got
okay.
it's indicted in 2023, so it's open.
I see. Okay.
Criminal attempt to commit a felony, possession of a knife or a firearm during a commission. Yeah, that's it.
That's it. 21
Mr. Brown, I'm so sorry. I'm trying to catch up with this case. What's your state's recommendation? I know that's a
No.
Katrina Rainey, and apparently they are married.
Not a problem, Your Honor. $1,500 good bond, no further violent contact. Well, no further contact. Stay away from the incident location. Complete DV training, and that's it.
Okay,
No alcohol or drugs without a prescription. I should say that this started over alcohol.
understood. Is Katrina Rainey present, or Mr. Dupree's sister by any chance? No? Okay. Mr. Ahmed? Oh, I'm sorry. You're representing Mr. Abraham Ahmed? You're representing him?
Yes, Your Honor, and I believe Ms. Rainey is on the Zoom.
I think we're
No
going to
one
bail
is
from this.
responding. Is it the Google Pixel 7a? Is that her?
I believe so, Your Honor.
You
All
believe
right.
so? You
Miss
don't know.
Grace, could you prompt this person on Google Pixel to unmute and start a video?
I did, Judge.
Okay. All right. Mr. Abraham, she's not. There she is. Oh, okay.
Hello.
That's her.
Good
Okay.
afternoon.
Good afternoon. Could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. And Ms. Rainey, according to the warrant, this just occurred a couple of days ago. So what would you like to tell us?
I didn't know he had a warrant, first off.
Well, funny things happen when the police get involved. One of them is a warrant gets issued.
Soundbite.
Okay, so I want to start by saying this. We just recently lost our son. He was murdered back in August.
Whoa.
And yes, Mr. Dupree, he's been drinking, grieving, going through it. So have I, not telling the truth. But at the end of the day, I'm going to allow him to come home because we're both dealing with situations of our son, and it's just been a hard time right here at the holidays right now. I will look past and I will forgive what he did, but we will have to sit down and have a long conversation.
All right. Thank you, Ms. Rainey. I really am sorry for your circumstances. I'll take that into consideration. Mr. Abraham?
Yes, Your Honor. Mr. Dupree is 45 years old. He has his high school diploma. He works as a forklift driver and at a warehouse as well. Before that, for about, I think, until about 10 years, roughly.
Yeah, I worked at Maricopa for 10 years.
Yeah, Maricopa, yeah, for about 10 years. He's been in Georgia his entire life. He has all of his family here. He has his 4-year-old daughter, a 10-year-old daughter, 21-year-old son, and then 24-year-old son, and then the 22-year-old son is the one who was just recently killed this August, unfortunately. As to his address, he has a good address where he lives with the alleged victim. And as to bond, Your Honor, for the reasons that Ms. Rainey just said and all the reasons I've listed, also in addition from the fact that Mr. Dupree works at the same company with the alleged victim.
Yeah, we work together.
Okay.
They share 3 sons. In addition to all that, Your Honor, we would just request it be signature bond, no further violent contact, and no stay away. This arose out of a dispute about his son's ashes, Your Honor.
I read the warrant on that one. So just curious. I'm going to issue a no violent contact, but you both work at a Maricold, at a warehouse, or in these?
We work at PVH now. My previous job was at Maricopa.
I see. Okay, understood. Thank you, Mr. Abraham. On the simple battery, this is going to be a $1,500 signature bond for pretrial services. And I'm going to make it a level 2 report, which means that Mr. Dupree must report to pretrial services twice a month. No violent contact with Katrina Rainey, which means that from this point onwards, Mr. Dupree, there shall be no physical and no verbal altercations with Miss Rainey. If you feel you cannot comply with that, you either vacate the premises or temporarily vacate the premises until
leave.
You can be assured there can be no altercations between the two of you. No illegal drugs, no alcoholic beverages, and no weapons and no firearms. You will be subject to random screens by pretrial.
She's rocking
to make sure that you're not consuming any alcohol and not consuming any alcoholic beverages. You will attend and complete 4 anger awareness classes with pretrial services. And if you violate any of these conditions, if you get arrested again, or you don't report to court when summoned or to pretrial, your signature bond will be revoked. Thank you.
Thank you, Your Honor.
What did it say about a warrant? Is that a warrant?
That was just what it's still.
Okay, so that took care of the second add-on
right,
calendar.
We're gonna bail from this. We're gonna bail. It is time. It is time. Oh my goodness, we've had a crazy day. This New Year's week has been a little bit different. Beginning with brushing my teeth with hydrocortisone, which I don't recommend. 0 out of 10 stars. Do not recommend. It's been a little bit wild, but wow, hard to hear that. Hard to hear what they're going through. We hope to get back to a real trial next week. That's our plan. Hopefully early in the morning. We have a couple options out there that are starting, some that are in jury selection, some that might actually begin. So we'll be back to court watching, which means we'll probably have a little bit bigger crowd here and probably some new people. So let's just be maybe make it our collective New Year's resolution to welcome people and help them gently understand what we do here and how we do it, and then just encourage friendly, polite dialogue, and it'll be great. So. With that said, we're done. We're done for today. We're done for the week. Amber's here. Hope to be back to normal tomorrow. Amber, I know that illness, it just lays you flat on your back. It's a pain in the butt. Appreciate it. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again Monday morning. It's probably going to be about 8:45. We're going to get started. Hopefully, fingers crossed, a new trial. We'll announce everything then. Trust me, we pick good ones. So no announcements yet, but lots of good trials coming up this year. There's a lot on the schedule. So, it's going to be great. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again Monday morning. I think I already said that, so you got it twice. Monday morning. Until then, have a great weekend, and be safe whatever you do. If you do something fun, take pictures, share them on the burner phone. As long as it's legal. I don't want to be subpoenaed to turn over evidence in your trial from the burner phone. That's the one thing I'm trying to avoid. So, Ivan, they're always friendly at the. Apparently they're quite welcoming. As long as you're tipping or throwing money or whatever it does you do. All right, you guys. On that note, we're done. You guys be good to each other. We'll see you on Monday.
The apocalypse may be upon us.
What more do we need to see?
If you could just use your words.
Hello.
You're talking about stuff that is not relevant.
There's nothing in the order that restrains you from talking to cats.
Well, thank you.